matter of 2012. But
Yes.
my only difficulty, my lord, 2, 3, and 4. 3 items are fixed in port number 17. So, my lord, either your lordship will accommodate me for timing, or my lord, it adjourn, my lord. But my lord, I have informed Mr. Halloi. He said that I will not be able to do it today. So,
Mr. Halloi.
So if your lordship says that after doing that, if I can come down, there is no difficulty. There are 3 matters for hearing.
Yes, Halloi has any instructed you?
No, Lordship, there is no instruction.
But I have informed him yesterday. He said that there is no, he has given his consent. For it.
Consent meaning he is not doing, or
No, he said that it will, you take adjournment. I told him that I'll be passing over for timing. He said that you take adjournment, it will be better because he'll not be able to. That's what he said. Now I do not know.
Just a moment, Lordship, I'm getting instructions.
okay. Otherwise, it is a matter of 2012, in fact.
I
That's right.
understand. I'm prepared. It's not that I'm not prepared. But we not those are 2009 matter, my lord, and 2, 3, and 4.
Okay.
So I have to do that also at the same time.
Okay. If he has some difficulty, otherwise we can take it up the matter at 2 p.m. also. If you have completed that other matters.
Let it be
And
kept,
if
my
it
lord.
is not completed, you cannot complete
Let it
them.
be not call, my lord. Let me finish and come back, my lord. So I'll just inform, my lord. In the meantime, my lord, whatever instruction Halloi gives, my lord.
Okay. Okay. Then if he takes any adjournment, you don't have any objection.
No.
In that case. Okay.
Maybe your lordship, my lord. One similar item has been, my lord, disposed of by granting bail in AB number 2927 of 2024. And this is pending before lordship. May take same FIR, same Thana, everything. So
You want to list
tomorrow.
listing
Yes.
tomorrow.
Same
AB,
matter,
AB,
AB.
Monday. Tomorrow may not be possible. Let it be on Monday. We'll see. Monday.
Monday, I will be out. That's why I mentioned. Otherwise, I would have meant. That's one of the same order. If your lordship granted to all.
Well, there may be other. Anyway, okay then.
May I please? Lordship, I beg to mention for one urgent bail, anticipatory bail execution for tomorrow.
Tomorrow may not be.
My lord, what
possible.
happened this is, petitioner is in medical college, my lord. And in a serious condition, I have annexed the photograph.
Monday.
Monday, my lord, it will be too late because Lordship kindly see the photographs.
No, whatever, on Monday it will be. It will be on Monday only.
May I please? I beg to mention this matter for listings, a bail application by them. Yesterday, the co-accused bail application was disposed.
Tomorrow not possible, Monday.
May I please, your lordship, I have to mention item number 20, Fidel list, my lord. It will be taken as 2, my lord.
Item number 20.
20. As 2, my lord. The first of, my lord, there is another case, my lord, hearing matter.
No, after the motion matters, we may start the bail hearing also. That's why.
That is why, my lord, I
Ah.
mentioned it will be taken as 2, my lord. Another hearing matter is there, my lord, so I was decision.
2 may not be possible.
But 2,
2 other hearing matters will continue, so it won't reach there.
Your Lordship, I beg to mention item number 14. Item number 14, Your Lordship, of today's list. Your Lordship, I beg to mention for on behalf of Mr. Sudesh Kumar Singh, Your Lordship, Senior Counsel, he is unable to come today. So may I pray this matter may be listed for hearing after vacation, Your Lordship?
You're for the petitioner?
Yes.
What you have seen? What is this difficulty?
Yes, Mr. Sudesh Kumar Singh, Senior Counsel, he is unable to come to Guwahati today. So,
Okay. You want to record SK Singh? The youngest counsel is not in a position to, has some personal difficulty and not in a position to appear before the Lord.
after vacation, Your Lordship.
Just after vacation.
Interim may continue.
My lord,
Interim will continue till next date of listing.
I'm sorry to mention again, madam, it may be on Tuesday, madam, instead of Monday.
Sure.
Lordship, adjournment pair, Lordship, item 29, Lordship. In this case, we are led by Mr. M. Bora, learned senior counsel, Lordship. Assisted by Mr. S. Samaria, Lordship.
Then?
S. Samaria is not available today. That's why Mr. M. Bora instruct me to pair before your Lordship for adjournment, Lordship, because he needs some assistance from S. Samaria, Lordship. Can it be come up, Lordship, after vacation, Lordship?
Obviously after vacation. And the request could be. Okay.
I mention item number 50, my lord, with the consent of the respondent, my lord. We are for the appellant, my lord, the amicus curiae, my lord. The respondent number 2 is also the amicus curiae. They have also difficulty today also, my lord. Also may receive after
Who
vacation.
has the difficulty?
Both the parties, my lord. Appellant as well as the respondent, my lord.
You are for the respondent,
I'm for the appellant, my lord. You have taken consent also.
for the appellant, item
Yes.
number 15.
Yes, my lord.
But the person is behind the bar more than 5 years.
Yes, my lord.
Then? Quite a reasonable period, he is behind the bar, in fact. With the consent of, with the, as agreed by both the, no, with the request made by both the parties. However, both the parties are hereby asked to proceed with the hearing on the next day, considering the period of detention of the appellant. List accordingly after vacation.
Deeply obliged.
I beg to mention for listing this criminal appeal duly filed, your lordship.
Make a mention before.
I made a
court number.
mention before court number 11, your lordship, but since your lordship is taking fresh matter where conviction is below 10 years.
Talk to registry. I'm not going to allow. Talk to registry. He may allow.
My lord, I beg to mention item number 18. The conducting council is having some personal difficulty, my lord. It may come after vacation.
Conducting council is who, from whom you are appearing?
P. Deka.
P. Deka. In item number 18,
Yes, ma'am.
P. Deka is
In a
appearing, huh?
My lord, GM Sai was a senior.
Because name of P. Deka is not here. Have you informed the other side?
Yes.
Of the revision, huh?
Yes, ma'am.
Informed
Yes.
the consent of court after vacation. Yes, Mr. Halu, it is the case was there. In
Yeah.
fact, item number 6.
Lordship. They rang me yesterday.
Yes.
They told that they are preoccupied with some cases in court number 1 or something like that.
Yes, just he informed me, yes.
So therefore, I told that if you are preoccupied, I cannot alone argue the case. It is their case. Appellant have to argue their case, then after I'll make my signature. So likewise, I have actually given consent.
Otherwise, see, it is a 2012 matter, in fact.
Correct.
Yes, Agarwala has most probably the other preoccupied. He is having 3 matters in other matter. Yes.
It has come after vacation. Which is preoccupied.
After vacation for you. With a direction to both the parties to proceed with the hearing on the next date without any adjournment, without further adjournment. eh? Both the parties agree to the fine. Okay.
Item 1, promotion.
May I please, your lordship? Lordship 482 application in connection with Shunapur PS case. Lordship FR is page 11.
Yes. Now, what is the stage of the case? Whether it has already been charged sheeted or not yet?
Not such.
Not charged sheeted. Still under investigation.
Yes, lordship. Lordship, already the main accused granted bail this honorable court.
Hmm. It's a case of damage of under the prevention of damage under public property.
Yes.
So whether there's such kind of case can be quashed.
CD may be required because he has not also not annexed those bail orders structure. Income protection may be not exist.
Such a case, maybe co-accused may be granted with bail. I'm not on that. But directly, I don't know what is your role in this case. That has to be seen. So we are calling for the case diary only at present. Okay.
Before vacation, let's say.
Before vacation, not possible at all. Not at all possible. Immediately after vacation, we are trying to give.
Yes. Lordship, as per your convenience, any date after vacation.
10.
10. We are fixing it on 10.
God bless.
Item 20 for bail hearing.
May please, your lordship, but for the time being, lordship.
For the time being.
Yes, lordship. Yeah.
21.
Lordship, kindly agenda matter for the day.
Now, this is the case we have received this scan copy, Borua.
Yes, madam. Scan copy received, my
It-
lord,
it-
and
it's
notice,
a-
notice
it's a
also
ca-
served.
Pardon?
Notice also served, my lord.
Notice also served.
Sir.
And MSC Kalita is appearing also for as per number 2.
My lord.
As per this thing. It's a case of POXO or what?
POXO, my lord. Victim examined, my lord.
Hmm.
Now,
It's a-
available witnesses, 3 witnesses have been examined.
Okay. But obviously, they is seeking adjournment. Obviously, it will be after vacation only. It
Can
will,
it be possible before vacation?
no, not possible. Today is the date.
Then
If it is
lordship,
not-
after some time,
After?
sometime lordship.
Okay.
22.
Similar prayer mark for some time.
Now see, if the hearing starts, then this will go, I think. Because we are going to start hearing. Okay, okay, timing.
23.
Yeah, Mr. Law. Well, in this case, my lord,
Hmm.
allegation under section 8 of POXO Act and
Hmm.
354. And the-
Amicus is there, yeah. Okay.
And the petitioner was arrested on 4/12/2023. Today
4,
is
12?
2023.
Hmm.
Statute case, my lord.
Yes.
Today is now 1 year, 8 days. Have been in custody.
Hmm.
And punishment is, my lord, 3 years. Section 8, my lord, not section 4. So, my lord, without, and case is the the merit of this case, my lord, if we go to the FIR, my lord, touch is something, just touched, nothing else. So under such circumstances, my humble submission, my lord, 1 year, 8 days in custody.
Just tell us, victim already been examined?
No, my lord. Victim is yet to examine, my lord. Yet to examine, my lord, let the mother victim examine after that, my lord.
My
She
lord,
is still,
medically
my lord,
examined.
7 years old, my lord. God.
Good.
Yes,
My
my
lord.
lord. Aged about 7 years.
My lord, may I go through the FIR? My lord? And this may I go through?
No,
the-
no, that's why it is cases registered under 8.
Yes.
There is no allegation of any penetrative sexual
yes,
assault. That
ma'am.
is understood.
Yes.
But the girl is 7 years. That is the only issue. And your case may be different, but otherwise there are maybe probability of tampering the witness. That is the main issue. If victim is examined, how many witnesses are already been examined?
No, my lord. Not yet, my lord. Because, my lord,
Case is at this stage? What
1/4/2024 charges frame, my lord. After that, my lord, someone issued, my lord. One day, my
One
lord,
for?
1/4/2024, my lord.
Hmm.
After that, someone issued to the prosecution witnesses, my lord, and they have appeared also, my lord.
Hmm.
But, my lord, due to the absence of the counsel for the accused person, they could not be examined before the trial court.
Due to absence of the counsel, accused counsel for acha.
My humble submission, let the victim examine. After that, my lord, his
So, my
verification
lord-
may be considered.
Since April to December, my lord, 8 months have been elapsed, even nothing progress done after training time.
No, I have already submitted, my
So,
lord.
my lord-
Witnesses were present. But due to absence of the counsel for the accused person, they could not be examined.
So, my lord, should I remain in jail for 1 year, 8 days in custody? And offense is punishment is 3 years. So, my lord, I am a local person who will abide by all conditions, appear in every days before the trial court, my lord. And person is in 50 years of age at the time of committing offense. And I have my lord, my grandchildren. I have with also.
That's why you should not do all these things.
So,
no?
it's
You
right,
have
my-
the grandchildren.
right.
He is your, I mean, the girl with whom you have alleged to have been committed such nasty offense. It is these things. She's also like your grandchild only. That is the-
I am at my shop. I am a shopkeeper. I am at
Yes,
shop.
yes, you are a
This is-
shopkeeper,
yes.
whatever.
I am at shop. The allegation is like that she visited the shopkeeper shops and something has done it at shop, my lord.
Mm.
This is the case, and if I go to the merits of the case, I will also ground. And in fact, I am denying, but I'm not saying on that. I'm saying that my lord, 1 year, 8 days have been in custody. Section 8, my lord. So, my lord, I'm seeking bail, my lord, not seeking my lord the acquittal, my lord.
Yes, what do you want to say? Sorry.
Medical report also, there are injuries in a private parts.
A medical report. Where is the medical report? In which page?
Page 23,
Mm.
hymen torn.
Oh, yes.
The allegations are serious, Your Lordship.
Tenderness over anterior wall of the vagina also.
Yes, Your Lordship.
Heard Mr. H.R. Chaudhary, they learned it.
Even the hymen torn, my lord, that cannot be the reason for this offense. Because hymen torn in many other ways, my lord. So.
That is
Section eight,
understood.
This one.
That is known to us. Heard Mr. H.R. Chaudhary, the counselor and counsel for the petition. And also heard Mr. Raji Borwa, the petitioner PP, appearing on behalf of state respondent. And MS B. Chaudhary, the learned amicus curiae, appeared on behalf of the respondent number 2. The scanned copy of the case record has already been received. Peristin had put side. It is submitted by Mr. Chaudhary, the counsel for the petitioner, that accused is behind the bar since 4/12/2023 until date 23, and hence considering his period of detention, he may be under on bail. The case is charged at under section 354.
354 IPC.
354 and reduced section 8.
8 of POXO.
Reduced section 8 of the POXO Act, wherein the penal provision is only for 3 years, and he has already spent more than 1 year in the jail, in the custody. He further submitted that he is a 50 years old person and is a local resident of the addressed place, and there is no scope of absconding even if he is allowed to go on bail. Or rather, he will appear on each and every day before the learned trial court will post. Mr. Borwa, the learned additional PP, submitted in this regard that the charge was framed on 1/4/2024, and thereafter the case is fit for evidence, but till that the victim could not be examined in the case, who is stated to be a 7 years old minor child. Further, he submitted that on one occasion, the PWs were also present, but due to adjournment prayed by the learned defense counsel, the witnesses could not be examined. Accordingly, he submitted that till the examination of the victim, the accused may not be enlarged on bail, as there may be probability of tampering with the evidence of the minor. Next para, MS Chaudhary, the learned amicus curiae, on behalf of respondent number 2, submitted in this regard that the victim was a minor at the relevant time of incident. At the relevant time of incident, the victim was only 7 years old age, and her medical report also supports the case of the prosecution. Accordingly, she submitted that at this stage, the accused petitioner may not be granted with bail. Next, considering the entire submission made by the learned counsel for both sides, it is seen that and it is found admitted that the accused is behind the bar for a considerable period, but considering the nature of the offense and also considering the fact that the victim is not yet examined, this court is of opinion that I find that the releasing of the accused on bail may hamper or tamper with the evidences of the witnesses, especially the minor victim. At this stage. Rejected at this stage.
My lord, I may be approached again after examination of victims.
Huh?
I may approach again, my lord.
Oh, yes, you are at liberty, you can approach.
24?
Mr. what have we selects in court number
Huh?
17. My senior selects in court number 17, Lordship.
Water court.
Yes, Lord. Lordship may fix in the month of January.
Consider
So you're praying for adjournment.
yes,
Oh, who will appear
Mr. S. Bothabula.
as Botafoe? He's not available today.
No, he's available some.
You want an adjournment.
Yes,
Okay, what kind of case this one?
Lordship, it's a solicited matter, already charge has been framed. And Lordship, status report was called for that we have received. Lordship may kindly go through it.
Okay, he praying for adjournment. Otherwise, evidence is
Yet to be, trial proceeding is yet to be initiated.
initiated.
Yes.
The case is of under which section or it's a NDPS matter.
NDPS.
And he is behind the bar since
Since Lordship. my lord,
24-1.
So 2601 to
2601.
2024, date of forwarding.
Lordship, if possible, Lordship, first week of the January,
First week of January,
because he's behind the bar, Lordship, plus almost 1 year.
yes, is behind the bar.
Okay. Case is in evidence, yes.
First week of January, I think it's not possible. হ'ব জানো, পাৰিব?
Okay, BA,
After vacation,
after vacation, first week of January.
and that only after vacation, immediately after vacation.
Yes.
Immediately after vacation.
That may be, any date.
Date we don't have. Immediately after vacation will rather help you because registry may put up the matter
All of
immediately
it.
after vacation. Because otherwise we don't have any date because sport, third is a working day almost, and then 6th to 10th, almost 4. And then
Yes.
again, it is BU vacation. So may not be possible. So immediately after vacation, I'll put here.
Outer Lordship.
As bought up, I have ready immediately after vacation.
Hello, Blush.
Scan copy of the LCR along with the status report has already been received.
For orders, item 2.
Please, Lordship, my lord, the petitioner, my lord, for Lordship, my opinion, my lord, has been convicted under section 6 of the POCSO and 363 of the my lord IPC for commission of offense, my lord. We have a minor girl, my lord. This petition is my lord consideration for the my lord stay operation of the impugned judgment, conviction and the sentences, my lord, and the fine.
Just a
and
second,
consider the
have you
bail.
taken steps for the, this is a POCSO now?
My lord,
Notice has already been
my
issued. Oh, yeah,
appeal,
appeal.
I
Okay,
appeal.
okay,
My lord.
okay.
Basically, case is this, my lord. Petitioner, my lord. I have the behind the bar, my lord, since my lord. 17/3/2003 from the date of judgment, my lord. My lord, the lords may come to the my lord. Judgment of the order, my lord, that last portion, my lord.
In appeal or in appeal?
The appeal, my lord. I have not annexed the IA, my lord. Page 32, my lord. This is the operative part of the judgment, my lord. Accordingly, in view 32, my lord. Accordingly, in view of the discussion made above, the court has no hesitation to hold the accused person so is guilty of offense under 363 IPC under section 5 of POCSO, punishable under section 6 of the POCSO Act. Hence, in the light of the evidence laid down in the prosecution, the accused person Singh is convicted under section 363 IPC and under section 6 for POCSO Act. My lord. So, my lord, the conviction is for my lord 10 years. Is in my lord page 33 with fine of rupees 10,000, my lord. In case for section 6, my lord, for my lord, for section 6 POCSO Act, my lord, 363 for IPC, my lord, 1 year imprisonment, fine of 5,000 rupees, my lord. In default, 1 year, 1 month more, my lord, because of imprisonment, my lord. My lord, in fact, my lord, though it is under section 6, my lord, there is the debtor, as has been not determined, my lord, whether she is, the victim is, my lord, below 18 or 16 or, my lord, above it. According to me, she is above 19, my lord. So that's why, my lord, we have to see whether, my lord, she is prior to, my lord, for consideration of bail, my lord, we have to see whether she is major or minor, my lord. So, my lord, she may come to the evidence part, my lord. Yes, sir. Additional objection, sir. The learned PP also has filed my lord written objection. May I come to the my lord evidence of
Written
my lord?
objection you have not filed.
They have filed my lord.
No,
I have,
not yet filed.
yes.
Lordship may come to the my lord
Written
evidence of
objection
PDF.
not yet filed. You also want to file any written objection?
I would like to file the objection.
Since there is a mandate under section 389 of.
Yes.
My lord, state has
Section
filed
one.
my lord.
Hmm?
State has filed. State has filed objection. Only my lord learned friend my lord private
Oh, that's
respondent
nothing
my
to
lord.
do.
State
But
has
as
filed my
per,
lord.
that state has already filed.
Anjuara Begum my lord, the learned PP has filed on my lord. Date my lord, date possibly my lord 4/8/2023. But service copy received on month 4/8/2023 my lord.
Online it could be.
Online showing.
Huh? Online is showing. ইয়াতে এটা আছে আচ্ছা আচ্ছা ইয়াতে আছে নেকি চাওকচোন ইয়াতে আছে নেকি? It is kept in appeal in fact,
Yes.
written objection.
My lord.
We have seen now.
Appeal, Lordship, it is the IA, Lordship.
No, I is kept in appeal.
Yes.
My lord, here they have
I mean,
filed-
389 objection is kept in appeal, I think.
Yes,
Hopefully, my
but
lord.
it has to be put on with along with the IA motion.
But I don't know the as per registry office note, kept in criminal appeal so and so. It's there only.
Objection has to be given in respect to the IA only.
I am my lord. Here also my lord, post title.
Yes.
Post title is interrogatory application criminal num 4/12/2020 in criminal appeal num 17/2020.
Yes.
It is only for my lord I.
So otherwise your objection is here, state objection is here, and yours we don't have.
Yes.
Uh,
I would like to file the objection. Lordship.
You want to file?
Yes, I will.
My lord, last 2 times my learned friend they
No,
did
no,
not pray
no,
for
no,
filing
I am
objection.
not getting
When
the
I
copy. I am
ready
not
for.
Yes, I am not
My lord,
getting
this
the,
is not-
I am not getting the appeal memo, Lordship. Only the IA was served to me. But last date only, when after my request, Lordship, he furnished me the appeal memo, Lordship. And therefore have some time to file the objection, Lordship.
My lord, there 2 days appeared, my lord. My learned friend, my lord, on last, prior to that, my lord said, I have missed, copy is not with me. I forward that copy, my lord. That last that could have paid for my lord. Objection.
Later after objection, Lordship, I will after vacation, Lordship, I will, in the meantime, I will file the objection.
His appearance is not recorded here. Anyway, on 23rd of May 2023 was the first date of IA. When objection from the public prosecutor was allowed, in fact. And then on the last occasion, there was an adjournment, whatever, on 27th.
To my knowledge,
27th,
my
yeah.
learned friend appeared 2 times.
No, no,
2 days, third time. my
in
lord.
the IA, not in the appeal, because I am not getting the copy. I am not getting the copy of the appeal. Actually, I am only getting the. I got only the IA, Lordship, and therefore, after request to my learned friend, he furnished me in the last occasion, Lordship, and therefore kindly fix the matter after vacation, Lordship. In the meantime, I will file my objection, Lordship. That's.
For consideration of I am my lord, my only moot question is whether she is major or minor, my lord.
No, that is very categorically explained in the judgment, Lordship. In
There is
para
no,
20, Lordship.
there is no proof, my lord,
Para
that she is
20,
minor.
Lordship. Para 20, Lordship, in the judgment, Lordship. It is categorically, specifically explained. And but one school certificate was exhibited before, was seized by the IO, Lordship. From the mouth of the IO, it is rendered that regarding the school certificate, Lordship.
That is photocopy, my lord.
No, whatsoever is, maybe it will come in the final hearing of the main appeal, Lordship. Now we are on bail, Lordship. There should have the probability, initial probability of the success, Lordship. It should be
That has
required,
to be
Lordship.
there.
Yeah.
Is my learned friend argue like this and I'll proceed, my lord then.
Heard Mr. M. Sarnia, the learned counsel for the petitioner, applicant oblique appellant. And also heard. As Ashish Paul, the learned additional PP appearing on behalf of state respondent.
So miserable in.
And you're Mr. J.K. Goswami,
Yes.
J.K. Goswami, the learned counsel. Learned counsel appearing on behalf of this respondent number 2. It is seen from the office note and from the record of appeal that the state respondent has already filed a written objection against the present, against presumably the cover. Full stop in this regard, Mr. Goswami submitted that he needs some more time to file his written objection as he received the memo of appeal only on the last occasion, and accordingly he needs time for the preparation of the same. Prayer allowed, list accordingly. It will be after vacation date is not possible for us. Or if it is, if we want any date, then it will come obviously after view vacation only.
My
It will
lord,
do, Saranya, after
I'll
view
fix,
vacation,
I'll pray for fix the date, my lord, because
then it will be after view vacation.
my lord,
After view vacation. 22nd of January.
23rd, my lord, because it's a bail hearing, most hearing day, my lord.
Oh, 23rd,
23rd.
Thursday.
If not 22, then 24. 23rd, we already fixed many matters.
Then 22, my lord.
22. 22nd.
High level.
Appeal approved, again, another. List according with detail.
Item 3.
Hello, this is quashing petition, my lord. My lord, this is, next one is,
Justice. Service is still awaited for 2. And the scan copy is also not received, in fact.
but I, my lord, personally search in the concerned trial court. Is records, it is online, it is showing that it is sent, my lord.
Now, at this stage, it's not possible for me to say anything. But as per report of the office note, on 29/11, it is reported that LC has not been received. And the postal remark is also suggested it is answered due to insufficient address. Do you have any proper address?
I don't know, my lord, this is the address of the missing kitchen where his owner is staying in my house, how it is insufficient, I could not understand, my lord. How it is postal person has been managed, I don't understand. Because the disputes, the civil dispute is going on, the same property. Missing kitchen is the same location, is standing last for more than 7 to 8 years.
Here your address is Dhruva Thakuria, is it about so and so, date so and so.
That restaurant.
But you have sent the address not under the address of Missing Kitchen.
But the same address, wherever he that is written in the Ajah, he complained.
In complaint, this is the address.
Yes.
Resident
Then
of
my-
Hyderabad,
what-
Tiniani. Can you collect the house number, etc.? Because Hangrabari is a quite a big area, in fact. Any particular thing, if it can be
Then I
collected,
may be allowed to serve the notice in the missing kitchen proprietor itself, proprietor, the Nivedita EM. Through her,
through proprietor.
proprietor, Nivedita
Can
EM.
it be possible? Okay, then. Through proprietor. Otherwise, the address is correct. This one.
Address is correct, they are managing the things, because they last 7 years, their suit has been disposed, they are dismissed. My counterclaim is going on. And to harass these things, well, this is already barred in the All India IOC case, also it is saying that to some settle the dispute civil suit, they are always taking the course of the criminal case. This is not fair and this is not acceptable. So this is the things. And is only the person 75 years old. The offense, he is showing this stick. And that is they try to park their vehicle inside my campus, violating the all agreements, clause and everything. So on that issue, some dispute arises. So
I admonish them, being a elderly person, 75 years old, I am showing this thing. This section is drawn under section 506, and moreover, the charge sheet has been filed by the ASI. He is not authorized to file any charge sheet as per the 161 and 36C of the police manual. He's not been authorized. So that is charge sheet is also go, itself will go. So this is my case.
Heard Mr. P. Mohanty, the learned
Negative
counsel for the petitioner. Also heard Ms. S.H. Bora, the learned additional PP appearing on behalf of state respondent. From the office note dated 29/11/2024, it is seen that the notice issued on respond number 2 returned unserved with a postal remark and imperative commandable insufficient address. And further, the scan copy of the LCR is also not received. Not received.
May I interrupt, my lord?
Just a second. The LCR has not been received. Issue reminder. Rest you will take necessary steps. Mr. Mohanty further submitted that the person, the address which is which was reflected in the FIR. No, the address is the proper and correct address of the respond number 2, and the which is shown in the FIR. FIR of this case, FIR also. However, he submitted that as a person is he is working in Michin
He
Kitchen.
is a missing kitchen manager.
He is working as a manager, Michin Kitchen. The Mr. Mohanty prayed to serve the summon key notice.
Dusty.
True, not Dusty. Dusty is not true. Through the proprietor of Michin Kitchen. Michin Kitchen. Ki naam kole? What is her name?
Proprietor now.
Proprietor name is Nivedita Yen.
Nivedita
Yen Pegu.
Nivedita Yen Pegu.
Pegu.
Prayer allowed. Let the press notice be issued to the respond number 2 through the proprietor of Michin Kitchen, so and so. So raise the post.
Melody as well as a Dusty also, because sometimes it's not very possible and they may also refuse. I am staying in the ground floor and the missing kitchen is the first floor, my lord.
Somehow try to.
And second thing, my lord, this calling of the scan copy, that is probably the third time order has been passed by your lordship.
Is it?
Third time. Earlier 2 occasions that was called for. So at least this time this should
When it was called, I don't know.
initially on
It is not here in the orders. Only one order is there, that is on 27/9. Thereafter, there is no such kind of order.
Yes.
order was
That means in the earlier occasions, all our adjournment prayer are there.
Yes.
And only 27/9 only the case diary was called for
Yes.
and steps for steps.
Issue notice.
But the first day also that was called for as per my information. And
I cannot say because it is only the
not
adjournment
reflected,
prayer.
it is not reflected, I cannot say.
Because only the adjournment prayer. Anyway,
In my petition also that is not reflected.
yes. List immediately after vacation.
Well, date may be given, my lord, because the old person, the case is going on in trial court, so that's a difficulty. Right?
Day 9.
On 9th, my lord, is possible, my lord.
No.
10, 11, 10, 11, my lord.
From 10 to 17, 10 to 19 or a holiday.
My lord, the 9th can
Only
be-
after vacation. Then it will want any date, it will be only
Then,
after
my
BU
lord,
vacation. BU vacation.
then lordship fix on 20th of January.
20.
20.
Date.
Item 4.
Also services. I think it's not been.
Not yet received or not yet called.
These services.
Here LCR is not called. Your state is party or no?
Item 4. 4 state is a party here. It's item 4.
Item 4.
Yes.
Here also same condition.
Not sure. Whether notice is served upon respondent number 2 or not.
In fact, my lord, about 1 month back, I have taken the steps. Now, initially, the steps was routed through, my lord, the wrong police station, Dispur. It ought to have been, my lord, through the Satyabari police station.
Satyabari, yeah,
Yes,
yes.
on the last date, my lord, my learned friend had apprised your lordship that eventually it has been routed through Satyabari. So that information has to be given to your lordship whether it is served or not. And on the last Saturday, my lord, coincidentally, the IO did not appear. It is fixed for, my lord, the examination of the IO. Now, my entire case is, my lord, that after examination of the PW 1 and 2, the charge has been altered to a grave offense. So therefore, I filed an application saying that I must be, my lord, given the opportunity to further cross-examine them. And that application was rejected, my lord. And thereby, my lord, I have approached your lordships challenging the rejection order by the trial court. So basically, this is the case, madam. And eventually, my lord, my humble submission is,
Yes, do you have any instruction regarding he is submitting rightly because Satyabari and Dispur, there was a place between, I think.
Actually, please to go on.
Satyabari হবলে প্ৰথমতে dispute দিছিল পাছত কিন্তু last time আমি বৰুৱাই ক্লিয়াৰ কৰিছে কৈছে Satyabari দিছো
It should be Satyabari.
last time এতিয়া কৰি গলে
February the whole history.
আর মানে আপনার
At 2 p.m.
Okay, let me see. 2 p.m. I don't know, may not be possible also because many matters are fixed at 2 p.m. in fact.
at 1 mile before your lordship rises up.
Take
12:30.
instruction, if he takes
Yes,
instruction.
I'll be
come.
here, ma'am.
For the
I'll be-
time being.
Yes,
Okay,
for the time.
time, okay.
25, 26 of the supplementary list.
Well, this is also quashing. And the second one is sufficient because one of the criminal petition 8, because first one that was I quashing for the affair. And the second was for the charge sheet also along with. Subsequently, during the pendency of the first one, the charge sheet was filed.
Criminal petition 538 was your earlier petition.
Yes, first one. First one, that was I challenge this charge sheet. This is a affair I challenged my lord quashing for. And second was one of the charge sheet during the pendency of that case, the charge sheet was filed, so I came in the second one. But there is
What
a
is the position
violation,
here?
my lord.
I have received any of everything.
This was issued.
Notice was issued, my lord.
Editor has been received there without signature.
Here the provision is that, my lord, they have violated the provision of the cosmetics act section 21, 23 and 36, my lord. 32. Because the inspector here is defined, this is a drugs inspector. He has to only see the documents and anything from the concerned by the person who is running a clinic, my lord, after getting all the license and the authority from the concerned authority, my lord. And they are saying that without having the authority, I have running the institution, this clinic, but I have produced and annexed all the documents.
Scan copy and received already, no? So you can fix it for admission hearing.
Admission hearing, since the answer has been received. Okay?
No, this is my lord. Actually, I was in, these are not possible today, my lord.
Hearing matters are there, lost to matters are hearing matters.
Then, my lord, again, the same thing will happen in the first one. There is no space to accommodate. So
No,
again, I have to fix insist on 20 of January.
20 also this time I cannot say 25 in this option. Heard Mr. P. Mohanto, the land council for the both the matters, so and so. And heard SH Bora, so and so. Answer has already been received. The notice on respond number 2 also return back to the signature is not there, na? Though it's written.
He's a police officer.
Is it police officer?
Police officer.
Note to ekku diya nai.
He was the
If
person who lost the affair.
It's Bora.
Lordship.
The question is that One acknowledgement we have is received back,
Lordship,
but that is without signature.
without signature, yes.
That might be some, due to some mistake that may be withdrawn.
That may be.
That may be due to some mistake that was not put in the signature and the acknowledged probably. But the,
No
whenever
signature.
acknowledges come, that means that the document has been delivered.
যিটো envelope আছে সেইটো ঘূৰি আহিছে নেকি অহা নাই ন? The envelope টো ঘূৰি আহিছে নেকি?
বহুত time আগতে suffer কৰি আছে।
ইহঁতৰ সেই এটা যে ৰিপৰ্ট থাকে চাৰ্ট কিবা এনেকা যে থাকে acknowledgement ফন্টে আছে নেকি চাওক তাতে আছে নেকি চাওক
But otherwise the acknowledge is not returned.
Maybe only the AD card is there. Normally the envelope should also be there. This time
No,
the
if
AD card.
it is returned back then only envelope will be there,
Yes.
otherwise envelope will not be there.
Mm.
মই ইয়াতে acknowledge চাইছো ইহঁতৰ এনেকুৱা কিবা এটা আছে নেকি চাৰ্ট বা কিবা এনেকুৱা
No, they should. Nothing as such, but there's an office note.
it's written হেৰি
Probably office will also accept it.
Only the AD card. Sometimes some postal remark is also there, but this time nothing is written.
okay then we will accept it then otherwise
Otherwise, it will
we
not.
don't have they do not they did not return the envelope in fact. So
After obviously it is served, then the document was
acknowledgement
returned.
signature
This
is
is out, yeah.
Sometimes we forget to obtain the signature also. This is the, might be the reason.
returned the respondent number 2 returned after submit to the acknowledgement is returned without any signature. However, it is deemed to be served on respondent number 2. Case is otherwise ready and list the matter accordingly for admission hearing on you was seeking 20
20 January.
20 can it be possible 20
22nd.
22nd
Must have been.
Of like.
Maybe 7?
yes.
Yes, my lord, notice is yet to be my lord, issued, my lord.
Yet to be issued.
Yes, my lord.
Otherwise, what was the delay?
My lord, delay reason for medical ground, my lord.
No, what was the number of
61
days?
days.
Of my lord,
61 days.
55 days. my lord.
Here it is 61.
It is only-
It is 61.
It is 55 days delay, my lord.
So are you paying any maintenance there or not? No pen maintenance.
I am paying my lord, maintenance my lord, 6,000 my lord. We have challenged by this petition my lord, enhancement part my lord.
What was the enhanced amount was?
My lord, now my lord enhanced up to 9,000.
9,000.
Yes, my lord.
That has been challenged.
Yes, my lord.
Issue notice or order করা নাই হ্যাঁ issue notice করে দিলাম I heard Mr. A. Hussain, the Islamic Council for the petitioner. Issue notice. This is an application in section 5 of the so and so. Issue notice. No formal notice is required to be served. You are the formal party, I think.
State is responsibility.
That's one number. Issue notice on respond number 1 to register with the administration. Steps to be taken within 7 days. List accordingly. It will be with it after vacation. After vacation.
Yes,
Date
ma'am.
cannot be fixed. After vacation.
After vacation, there is 2 vacation, my lord. One winter vacation and another is due vacation. There is no.
After vacation, registry will definitely verify when it can be fixed.
Obviously.
For hearing item 5.
Your Lordship, conviction is under section 22C for 10 years.
22C for 10 years.
For 10 years. One accused before your Lordship, initially in the FIR, 2 persons were named. And charge sheet was submitted against four persons. Other three are acquitted and present appellant was convicted. LCR is here. So may I read the FIR Lordship? That is in the LCR Lordship.
In appeal, you have annexed or not yet? Not annexed.
Not annexed.
Not annexed. That's well. Yes, in which page?
In LCR Lordship, it is designation will be different from my document. In exhibit part, it will be there.
Yes.
Lordship, may I kindly note the date, that is 23rd September 2021. This is to report you that on 22/9/2021 at 8:10 a.m. specific information was received from a reliable source that Mohammad Ali Hussain alias Dukia, that is the appellant before your lordship, son of so-and-so, Nagaon, has gone to Dimapur to procure illegal arms and is returning back with arms in a bus. So initial information was that he was having some, he went to procure arms, lordship. And in the entire trial, there were no arms was found. Accordingly, the information was shared with Additional SP Headquarters Nagaon with a request to share the same with Bukajan Police to take necessary action in this regard. Later, information was received from OC Dhilai PS, Karbi Anglong, that they have detained Mohammad Ali Hussain alias Dukia along with one Mohammad Rashidul Haq. He is acquitted at Dhilai while they were traveling in a bus coming from Dimapur, Nagaland. Accordingly, they were brought to Dhing PS. During interrogation, Mohammad Ali Hussain alias Dukia reveals that now this lordship may see that number one, 8-10 years back, he was arrested in a dacoity case by Dhing PS. No such case is presented during the trial, lordship. In the month of December 2020, he was arrested by Botodroba PS in a dacoity case. No such document found. And third, 2-3 months back, he came out from Gulaghat District Jail, arrested in arms-related case by Bukaghat PS. Further information was received that Ali Hussain alias Dukia is a drug peddler. This refers to Dhing PS GD entry number 568 dated 25/7/2021. Now this is a lordship GD entry which is prior to the present FIR, lordship. That is in the month of 25/7/2021 on a month. And my whole case is that this GD entry was never sent to superior officer in terms of section 42, lordship. Because if any information is received, they have to immediately send it to superior officer. Accordingly, general diary entry was made by Dhing PS GD entry number 514 dated 22/9/2021. The matter was informed to Additional SP Headquarters Nagaon sir and a proper authorization was obtained. Accordingly, a team was formed consisting of the following police personnel. So I'm skipping those names. I, along with police party, used departmental hire vehicle Tata Sumo bearing registration number so which was driven by Mohammad Riazuddin attached with Dhing PS. At 11:10 p.m., we, along with Ali Hussain alias Dukia, proceeded towards his house at village Dhupaguri Pathar. At around 11:30 p.m., we reached Dhupaguri Pathar. Two independent witnesses, namely Anwar Hussain and Ajmal Khan, VDP secretary, accompanied us from Dhupaguri Bazar. After reaching the spot, all procedure of house search was made and accordingly house search was conducted. During search, the following articles suspected to be drugs are found in one locked storeroom.
of the house, and accordingly the articles are seized by duly preparing a seizure memo. Now here your lordship has seen that one log storeroom. It is not a log storeroom, lordship. It was adjacent to a house. Here there was a house which was made of bamboo, lordship. It was open. It was not a locked house. In the evidence, your lordship will find that part. Duly preparing a seizure memo. So number one, black color polythene bag containing 326 numbers of strips of paracetamol. Here, lordship may kindly note another aspect. Strips of paracetamol. Here, comma was used. Paracetamol, dicyclomine hydrochloride, and tramadol hydrochloride capsules. So here, lordship, from the evidence what subject to correction, so if my learned, what my learned friend says, what I find, paracetamol, dicyclomine hydrochloride, and tramadol. So 3 tablets were found. In that inventory, your lordship will not find the specification of those tablets are not there. So whether the entire capsules are of tramadol or it is other capsules were there, that part is not there because I'm convicted under commercial quantity. So there has to be specific finding to that effect, lordship. Further, the following articles are seized from a cupboard in the bedroom of the house. So black color polythene and rubber bands were seized. So thereafter, it is to be noted that Ali Hussain does not run any shop to possess huge numbers of polythene bag, specifically black color and rubber band. The above exhibits are seized in presence of following witnesses. After completion of formalities, the police party departed from the PO at 12:45 AM and reached police station at 1:05 AM along with the seized items. It may be mentioned that I, being the sub-inspector of police, I am empowered by the governors of this notification. I therefore request you to register a case against Ali Hussain and Rasidul Haq. So 2 persons are named in the FIR. Now, lordship may kindly see the deposition of PW1. Here, 4 prosecution witnesses are examined. PW1 and 2 claim to be seizure witness. 3 is IO, and 4 is lordship that FSL expert, officers from forensic science. PW1. Let's see what it is.
Yes.
Anwar Hussain. I know the informant Ajoy SI Bormon. He was OC Dhin. I know the accused person. They are from my jurisdiction as Gaubura. Ali Hussain and Rasidul are from different village, but I know the both. The occurrence took place about 8 months ago in the night hour at about 11:12 in the midnight. The IO asked me and one BDP secretary Azmal Khan to accompany them to the house of the accused Ali Hussain to be witness of search of his house. The police had searched the house of the accused Ali Hussain in our presence. During search, we saw that the police had recovered tablets from the wooden house, Horihor, situated adjacent the main house. Police had seized the recovered tablets capsules and took possession of the same. I have signed the seizure list since I have witnessed the seizure. Exhibit 1 is the seizure list. Exhibit 1 is my signature. Cross. The accused are not from my village. They are from different village. I have been appointed as Sarkari Gaubura from 2003. As a Gaubura, police often calls me to accompany them in different operations and in different places. I have stand as a witness in some of these police cases. So it appears that he is stock witness. Police had named me as a witness and I have deposed as witness. There are other houses near the house of the accused. These houses belongs to his relatives. Ali Hussein has 2 wives and about 9-10 brothers. These questions were put just to show that the house which was adjacent to the house, so there are other people also who have the access to that house also. Ali Hussein, all his brothers lived separately with their family in the same compound. Ali Hussein used to stay in Dimapur since a long time ago. On that day, when police took us to Ali Hussein's house for house search, I saw Ali Hussein was sitting inside the police vehicle when I boarded it. Just I am again clarifying one aspect of it. This question was put because in the evidence your lordship will not find anywhere it is police said that I have said that contraband is kept in my house. I have never said. Police randomly came to that house and allegedly recovered those contraband, which is not in exclusive possession of the appellant. At that time of seizure also, he was in the vehicle. He has not led to that article to show the police. Police got down first and searched the house of Ali Hussein, including the wooden house. The wooden house is a storehouse. Ali Hussein was taken to police station directly from there after the search. I have not read the seizure list. I have put my signature as asked. I do not know whether the tablets, capsules belongs to accused or not. Now PW2 Lordship, Ajmal Khan. I know the informant Ajoy S.I. Burman. He was O.C. Dhin. I know all the accused persons. The occurrence took place about 6-7 months ago in the night hour at about 12 a.m. in the midnight. The IO telephoned me and asked me to come to Dhupaguri Bazar. I, along with Gaubura Anwar Hussain, boarded the police vehicle and accompanied them to the house of the accused Ali Hussein to be witness of search of his house. The police had searched the house of the accused Ali Hussein in our presence. During the search, we saw that the police had recovered tablets in polythene bag from the wooden house, Khorighor, situated adjacent the main house. Police had seized the recovered tablets, capsules, and took possession of the same. I have signed the seizure list since I have witnessed the seizure. Ross. I am VDP secretary. Myself and Anwar Hussain were in the post of VDP secretary and Gaubura since a long time. As a VDP secretary, police often calls me to accompany them in different operations and in different places. I have stand as a witness in some of these police cases. Police had named me as witness and I had deposed as witness. There are other houses near the house of the accused. The house belongs to his relatives. Ali Hussein has 2 wives and about 9-10 brothers. All his brothers live separately with their family in the same compound. On that day, when police took us to Ali Hussein's house for house search, I saw Ali Hussein was sitting inside the police vehicle. When I boarded it, police got down first and searched the house of Ali Hussein, including the wooden house. The wooden house is a storehouse. It was open. So that is what I was pointing out earlier. The wooden house is a storehouse. It was open. But in the FIR, they intentionally said it was locked. But independent that Caesar witness is saying it was open. Ali Hussein was taken to police station directly from there after the search. I have not read the seizure list. I have put my signature as asked. I do not know whether the tablets, capsules belong to accused or not. I do not know from where the accused was arrested. So from here, Lordship, I am just stressing on 2 points. That first, your Lordship has seen all his brothers live separately with their family in the same compound. So in same compound, 9-10 brothers they live. How the appellant is connected with the contraband, that is not there in the evidence, Lordship. Because it was an open house, your lordship has seen. And whether it was the exclusive, it was under exclusive domain of the appellant or not, that there has to be specific finding to that effect. Now, PW3, he is the officer in charge. On 22/9/2021, I was posted as OC Dhing PS. That day, I received an information from reliable source at about 8:10 a.m. that Mohammad Ali Hussain alias Dukhia have gone to Dimapur from Nagaland, to procure illegal arm and is returning with arm in a bus. Accordingly, the information was shared with additional SP headquarters with a request to share the information with Bokazan police. Later, we received an information that OC Dhilai PS Karbi Anglong had detained Muhammad Ali Hussain alias Dukhia and Rasidul Haq while they were coming from Dimapur. Later, they were brought to Dhing PS. During interrogation, Ali Hussain alias Dukhia is working as a drug peddler. Accordingly, Dhing PS GD entry number 568 dated 25/7/2021 was entered. In reference to GD entry number by Dhing PS GD entry number 514 dated 22/9/2021, I along with police team took Ali Hussain alias Dukhia towards his house at village Dhupaguri Pathar. So here also your lordship will not find that sentence that the appellant had disclosed that contrabands are kept there. That part is not there. They have taken Ali Hussain directly to his house. At about 11:30 p.m., we reached Dhupaguri Pathar and two independent witnesses, number 1 Anwar Hussain BDP and number 2 Azmal Khan Gaungura, were asked to stand as witnesses. We had explained them all the procedure of house search and they agreed. Both the witnesses accompanied us to the house of accused Ali Hussain and they were present during the house search. During the house search, we found the following articles in the storeroom and bedroom of the accused. So these are the articles which they have recovered. Again, that comma is there between paracetamol, diisoclomine hydrochloride, and tramadol hydrochloride. The seized articles were seized and packed in presence of the witnesses Anwar Hussain and Azmal Khan. We departed at 12:45 a.m. and reached the police station at 1:05 a.m. Ali Hussain do not have any shop to possess such a huge numbers of polythene bags and rubber band. So we suspected it might be used for packing drugs and narcotics. At the time of search, I have taken photographs of the place where contraband was concealed. I have also taken photographs of the accused along with the recovered capsules. I have recorded the statement of the seizure witness Anwar Hussain and Azmal Khan on the spot. I have drawn the sketch map and I have also prepared the inventories. Both the accused Ali Hussain alias Dukhia and Rasidul Haq were brought back to the police station along with the seized articles and documents. I have kept the seized articles in police Malkhana. I have also entered the Malkhana register. Thereafter, I have registered the FIR bearing Dhing PS case number 552 dated 23/9/2021 under section 22C and 29 of NDPS Act. I have endorsed SI Radhakanta Das with the investigation. There is record that accused Ali Hussain Dukhia was arrested in connection with Botodroba PS case number 178/21 under section so-and-so. Exhibit 1 seizure list, Exhibit 2 photograph, Exhibit 3 sketch map, Exhibit 4 inventories, and Exhibit 5 FIR. Signature. During the investigation, SI Radhakanta Das retired from his service and I had entrusted SI Surajul Haq to continue with the investigation. After completion of the investigation, the case culminated into charge sheet. Charge sheet number so-and-so. Cross. I know NDPS is a special act procedure of investigation should be conducted as per provisions of NDPS Act. And for search and seizure, we also have power under Code of Criminal Procedure Code and Assam Police Manual. The GD entry of Dhilai PS, District Karbi Anglong, entering the detail of detention of accused Rasidul Haq and Ali Hussain is not available in the case diary. The police officials who had apprehended the accused persons were not listed as witness in this case, as they have not recovered any articles. When the accused were detained at Dhilai PS, no arms were recovered from them. They were handed over with both the accused persons. We were handed over with both the accused persons at about 7:10 p.m. on 22/9/2021 at SP office Nagaon. We have brought them directly to police station from the SP office. We had not produced them before the magistrate, as no case has been registered against both the accused, so I had not produced them. On the basis of the information of apprehension of the accused and subsequently their handing over to us by Dhilai PS, we have not registered any FIR. Even though the information that accused are coming from Dimapur with arms was a cognizable offense. Ali Hussain Dukia is a drug peddler. That information was already entered in Dhing PS GD entry number 568 dated 25/7/2021. There is no written document of intimation to the superior officer after entering the Dhing PS GD entry number 568 dated 25/7/2021 and GD entry number 514 dated 22/9/2021. So he admitted that that is not there, but subsequently he tried to cover up that. Your lordship will find the GD entry made in official register by default. The carbon copy is always sent to the SP office. The document of sending the copy of GD entry number so-and-so is not in the case diary. So it was not there in the case diary that it was sent. And that's what he said, that GD entry made in official register by default, the carbon copy is always sent to SP. So I will rely on a citation lordship which says that sending of FIR to SP, that will not be compliance of section 42 lordship. The accused Ali Hussain alias Dukia and Rasidul Haq were in police custody when they were taken to their house and recoveries were made. They have gone to Dimapur for last 2-3 days. So here it is said that from 2-3 days they were not there in their own house from where the contraband was recovered. So they were not at home. The contrabands were recovered from the storeroom. Ali Hussain have 2 wives. Both the wives stays together with Ali Hussain. Though I have not specified the residing of first wife, I have not shown in my sketch map where the children or other family members reside. This is most vital because the place where the contrabands were allegedly recovered, the other residents are also there. His 9-10 brothers were residing there. So it was incumbent upon the IO to note all those facts, lordship. As per the sketch map, there is a village road on the southern part of the house of accused Ali Hussain. There is other residential house adjacent to the house of Ali Hussain. So other person's house is also there apart from his brother. I have not shown them in my sketch map, nor did I examine them as a witness. I have not collected any document of house number or specification from any authority identifying the house of the accused. The Gavra has accompanied us, who is a listed witness, and he had identified the house. I have not collected any document from the circle office. Because lordship, that the house which was adjacent to the house of Ali Hussain, that the appellant, that is in the same compound, other brother's house is also there. Therefore, this question was put whether any identification, those things were collected by him or not. Because the investigating officer have to show that it was under the exclusive possession of the accused at that house. The sample was collected by the IO in front of the magistrate, not at the place of occurrence. So I am not going to into that aspect because that aspect is pending before Honorable Apex Court under section 52A. Whether sample has to be drawn at the spot or before magistrate, that is, the judgment is reserved. So I am not going into that. I have not attached any copy of receipt of article in Malkhana. In my exhibit 4 inventories, I have not filled up the following column, namely column number 3. This is most vital, Lordship. In my exhibit number 4 inventories, I have not filled up the following columns, namely column number 3, that is quality, column number 5, mode of packing, column number 7, column number 8, and column number 9. Because all these things your Lordship will find in the section 152A subclause 2, that all these things has to be mentioned in the inventory. When the accused were handed over to us by Dhilai PS, we have not done any body frisking of the accused, nor the police officials of Dhilai PS had, as per my knowledge, and had done any body frisking. I have not made any prayer for confessional statement of the accused Ali Hussain before the magistrate. I have not made any prayer to record statement under section 164 CRPC of the seizure witness. The photographs exhibited as exhibit 2 has not been certified. So that 65B certificate is required, that is not there. I do not know the details of the Botodrova PS case number 178 of 2021. So as I have pointed out that although he tried to cover up that he was earlier arrested appellant, but this question especially put that whether he knows about the details, because mere mentioning the case number, that will not do. They have to exhibit that FIR or charge sheet or any document showing the name of the present appellant connected with that case. It is not a fact that the accused Ali Hussain and Rasidul are not illegal arms dealers or drug peddlers, and no contraband has been seized from their possession. It is not a fact that Exhibit 3 is not the house of accused Ali Hussain, and that the reason no neighbors has been listed as witness and examined. So this is the question where it was pointed out that the house from where it was seized. It is not a fact that I have not investigated the case properly and followed the provisions of NDPS Act. I am the informant of this case and I have done the vital initial part of the investigation. So that judgment already came up where it is said informant can be the investigator. Now PW4, Gitali Rava, on oath. On 24/9/2021, I was posted as Joint Director of Directorate of Forensic Science, Assam, Kahilipara on contractual basis.
No, not Gitali Rawat. He is DJ Hazarika.
Oh, I'm sorry, so DJ Hazarika, I'm sorry. That,
Yes.
I'm sorry. On that day, I have received a sealed parcel from my director in connection with Dhing PS case number 552 of 2021. Under section 22C of 29 and 29 of NDPS Act. The parcel consists of one exhibit enclosed in a seal envelope cover. The facsimile of the seal was found to be Superintendent of Police Nagaon. The description of article: one sealed envelope having another closed envelope containing a strip of 8 numbers of blue colored capsule. So here your Lordship will find that blue colored capsule branded as Proxim Spas. So these details your Lordship will not find in the inventory. I will take your Lordship to the inventory. Therefore, Lordship, that section 52A subclause 2 says that all the details has to be there. So whether the seized articles are the same which was sent to the FSL are same or not, to ascertain that aspect. Result of examination. On careful examination of the exhibits following United Nations drugs, so I'm skipping that part, Lordship. I have not mentioned the cross part I'm reading, Lordship. I have not mentioned the other components present in tramadol capsule in my report, since other components were not included in the NDPS Act. So what I have pointed out earlier that paracetamol comma was there. So whether those are same capsules or not, that aspect, for that purpose, this question was put. Whether the entire seized articles are of tramadol or some other capsules are also there. On 24/9/2021, I had received the sealed envelope when the director had received. I had not reported the date. In my report, I have not mentioned the detailed procedure of my examination. I have not mentioned the name of reagent used in the chemical examination. So these are the evidence before your lordship. Now, if your lordship kindly see the inventory which was exhibited as exhibit 4, lordship.
Inventory. Exhibit 4.
Exhibit 4. In exhibit 4, your lordship will find that narcotic drug substance control and conveyance, so that 3C26, that number is mentioned by hand, and thereafter quality, that is nothing is written there. Quantity, black color polythene bag containing human, so and so, each color is not mentioned. Then mode of packing, it is not written anything. Other identifying particulars of seized items or packing. So here also nothing written. Country of origin, that probably they will not know, but remarks, again nothing is there. Now, if I may take your lordship to section 52 subclause 2.
Yes.
52A subclause 2, where any narcotic drug, psychotropic substance, controlled substance, or conveyance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, or the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drug, psychotropic substance, controlled substance, or conveyance, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to identify of the narcotic drugs, psychotropic substance, controlled substance, or conveyance in any proceeding under the
So basically, serial is not there. Serial. Yes.
Exhibit 6, charge sheet. Second page I am referring to, where details of the appellant is mentioned. Ali Hussain, your lordship will find in column number 2. Now, my relevant paragraph is column number 16. Lordship may say regular criminal number, if known, nil. Then again, your lordship will find
Which item?
serial number 16,
16.
Roman 16.
Regular criminal.
Yes, nil.
Oh.
And then your lordship will find 23, serial number 23. Previous convictions with case reference, nil. So these documents they have not found, only mere oral statement in the court. And now I am relying on lordship that citations. Lordship may kindly say first Sukhdev Singh, that I am relying on paragraph 21, 22, 24, 25, 26, and 28. Lordship. In paragraph 22, Colonel Singh is quoted. Paragraph 22, Lordship will find 21.
Yes.
In the present case, the occurrence was of 4/2/1994. The trial of the accused concluded by judgment of conviction dated 4/7/1998. Thus, it will be the unamended section 42(2) of the NDPS Act that would govern the present case. The provisions of section 42 are intended to provide protection as well as lays down a procedure which is mandatory and should be followed positively by the investigating officer. He is obliged to furnish the information to his superior officer forthwith. That obviously means without any delay. But there could be cases where the investigating officer instantaneously, for special reasons to be explained in writing, is not able to reduce the information into writing and send the said information to his superior officers, but could do it later and preferably prior to recovery. Compliance with section 42 is mandatory, and there cannot be an escape from its strict compliance. Section 22. So that Colonel Singh is quoted, that grounds your lordship will find. Subpara A I am reading. The officer on receiving the information of the nature referred to in subsection 1 of section 42 from any person, he had to record it in writing in the register concerned and forthwith send a copy to his immediate official superior before proceeding to take action in terms of clause A to D of section 42(1). B. If the information was received when the officer was not in police station, but while he was on the move, either on patrol or the patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action as per clauses A to D of section 42(1) and thereafter, as soon as it is practical, record the information in writing and forthwith inform the same to the official superior. In other words, the compliance with the requirements of section 42(1) and 42(2) in regard to the writing down the information received and sending a copy thereof to the superior officer should normally precede the entry, search, and seizure by the officer. But in the special circumstances involving emergent situations, the recording of the information in writing and sending a copy thereof to the official superior may get postponed by a reasonable period. That is, after the search, entry, and seizure. The question is one of urgency and expediency. D. While total non-compliance with requirements of subsection 1 and 2 of section 42 is impermissible, Delayed compliance with satisfactory explanation about the delay will be acceptable compliance with section 42. To illustrate, if any delay may result in the accused escaping or the goods or evidence being destroyed or removed, not recorded in writing, the information received before initiating action, or non-sending of a copy of such information to the official superior forthwith may not be treated as violation of section 42. But if the information was received when the police officer was in the police station with sufficient time to take action, and if the police officer fails to record in writing the information received or fails to send a copy thereof to the official superior, then it will be a suspicious circumstance being a clear violation of section 42 of NDPS Act. Similarly, where the police officer does not record the information at all, does not inform the official superior at all, then also it will be a clear violation of section 42 of the NDPS Act. Whether there is adequate or substantial compliance of section 42 or not is a question of fact to be decided in each case. The above provision got strengthened with the amendment to section 42 by the Act 9 of 2001. Having referred to the above settled principle of law, we are unable to accept the contention raised on behalf of the state and have to grant our approval to the submission made on behalf of the appellant. Now, 24 is important, Lordship. As per the statement of PW1, no effort was made by him to reduce the information into writing and inform his higher authorities instantaneously, or even after a reasonable delay, which has to be explained with reasons in writing. He merely saying that it probably was sent, that will not do. They have to show it in writing also, that it was sent. On the contrary, in the present case, the investigating officer PW1 had more than sufficient time at his disposal to comply with the provisions of section 42. Admittedly, he had received the secret information at 11:30 a.m., in our case 10 a.m. But he reached the house of the accused at 2 p.m. Even when the distance was only 6 kilometers away and he was in a jeep, there is not an iota of evidence either in the statement of PW1 or in any other documentary form to show that the investigating officer was doing for these 2 hours was doing for these 2 hours and what prevented him from complying with the provisions of section 42 of the NDPS Act. There is paragraph 26, Lordship, 25. There is patent illegality in the case of the prosecution, and such illegality is incurable. This is a case of total non-compliance. Thus, the question of substantial compliance should not even arise for consideration of the court in the present case. The twin purpose of provisions of section 42, which can broadly be stated, are that now A, it is a mandatory provision which ought to be construed and complied with strictly, and B, compliance of furnishing information to the superior officer should be forthwith and within a very short time thereafter, and preferably post recovery, prior to recovery. 26. Once the contraband is recovered, then there are other provisions like section 57, which the empowered officer is mandatorily required to comply with. That itself to some extent would minimize the purpose of effectiveness of section 42 of NDPS Act. It is to provide fairness in the process of recovery and investigation, which is one of the basic features of our criminal jurisprudence. It is a kind of prevention of false implication of innocent persons. The legislature, in its wisdom, had made the provision of section 42 of NDPS Act mandatory and not optional as stated by the court, by this court in Colonel Singh. And next citation I am relying is Dashrath Singh, Lordship. That paragraph 13 and 13 to 15, Lordship.
Next one, Darshan Singh.
Dashrath Singh. Having given our thoughtful consideration, paragraph 13, I am reading, Lordship. To the submission advanced at the hands of the learned counsel for respondents, we are of the view that mandate contained in section 42(1) of NDPS Act requiring the reducing in writing the details pertaining to the receipt of secret information, as also the communication of the same to the superior officer are separate and distinct from the procedure stipulated under the provisions of the Code of Criminal Procedure. Subsection 1 of section 41 of NDPS Act provides that a metropolitan magistrate or a magistrate of the first class or any magistrate of second class specifically empowered by the state government may issue a warrant for the arrest of any person whom he has reason to believe to have committed any offense punishable under chapter 4. Subsection 2 of section 41 refers to issuance of authorization for similar purposes by the officers of the departments of Central Excise, Narcotic, Customs, Revenue, Intelligence. Subsection 1 of section 42 of NDPS Act lays down that the empowered officer, if he has a prior information given by any person, should necessarily take it down in writing, and where he has reason to believe from his personal knowledge that offences under chapter 4 has been committed, or that materials which may furnish evidence of commission of such offences are concealed in any building, etc., he may carry out the search of such arrest or search without warrant between sunrise and sunset, and he may do so without recording his reasons of belief. The two separate procedure noticed above are exclusive to one another. Compliance with one would not infer compliance with the other. So here why I'm referring this, because your lordship will see that the entire search process was conducted at night. And no such grounds of belief was exhibited, lordship, that he reduced his grounds for belief into writing and thereafter it was sent to officers. Lordship. Because 41 authorizes, he also said authorization is there, I'm not disputing. But apart from that, when he is searching my house, he have to record his reasons if it is between sunrise and sunset. In circumstances contemplated under section 42 of NDPS Act, the mandate of the procedure contemplated therein will have to be followed separately in the manner interpreted by this code in Colonel Singh's case. And the same will have to be assumed merely because the station house officer concerned had registered a first information report, which was also dispatched to the Superintendent of Police in compliance with the provisions of the Criminal Procedure Code. Now, paragraph 14. In the above view of the matter, it is not possible for us to accept the submission of the learned counsel for the respondent state that the registration of the first information report at the hands of the station house officer, police station Sahara, Panipat, and its communication to the Superintendent of Police, Panipat, would constitute sufficient compliance with the mandate of section 42 of the NDPS Act. In the aforesaid view of the matter, we are satisfied that section 42 of the NDPS Act was not complied with at all, insofar as the present controversy is concerned. Thus viewed, conclusion D, referred in para 35 of the judgment rendered in Colonel Singh, would fully apply to the facts and circumstances of the present case, and we left with no other option but to set aside the conviction and sentence of imprisonment of the appellant accused Darshan Singh, ordered accordingly. Now, third judgment, lordship, that Mohanlal's case, your lordship has published. Paragraph 8, your lordship may kindly see page 5. This is regarding, lordship, that the contraband was found from the house, lordship, that adjacent house of adjacent house. Now, as initially I have submitted whether I have knowledge about that contraband or not, that is relevant. And for that purpose, is judgment, lordship, that paragraph 8, lordship may kindly see. When one conceives, lordship, paragraph 8. Where one conceives of possession, it appears in the strict sense that the concept of possession is basically connected to actors of physical control and custody. Attributing this meaning in the strict sense would be understanding the factum of possession in a narrow sense. With the passage of time, there has been a gradual widening of the concept of the quotential meaning of the word possession. The classical theory of English law on the term possession is fundamentally dominated by Savigny-Ian corpus and animus doctrine. Distinction has also been made in possession in fact and possession in law, and sometimes between corporeal possession and possession of right, which is called incorporeal possession. Thus, there is a degree of flexibility in the use of the said term, and that is why the word possession can be usefully defined and understood with reference to the contextual purpose of the said expression. The word possession may have one meaning in one connection and another meaning in another. The term possession consists of two elements. First, it refers to the corpus or the physical control, and the second, it refers to the animus or intent, which has reference to exercise of the said control. That whether the appellant was having the knowledge that contravention is there, that part is absent in the present case. So in my humble submission, it cannot be said that the contravention was recovered from his possession. And it has come in the evidence of PW3 that he was not at home for last 2-3 days. He was directly apprehended from different district and he was brought to that place. This is my humble submission. And he is in custody since the date of incident, that is, Lordship, 22/9/2021.
Yes, but
This is an statutory appeal whereby appellant is convicted. The appellant is filed an application under section 374(2) of the CRPC lawsuits against impugn judgment and order dated 1/10/2022. Why the appellant is convicted under section 22C of NDPS and sentenced him to undergo rigorous imprisonment for 10 years. Basically, since the lawman has already submitted that has gone the evidence part worship, I'm not going, don't want to go deep to that worship. So as per the FIR lordship, lordship, as per ZD entry number 568 dated 25/07/21, OC Things received an information from a reliable source that Ali Hussain, along with other co-accused, are arms dealer and they will be entering Assam from Dimapur, Nagaland, with arms consignment. Now, upon receiving such information, OC Thing PS has sent messages to the district police headquarters in neighboring Karbi Anglong district, and thereby the suspects were apprehended and thereafter handed over to OC Thing. And upon interrogation of the two apprehended persons, suspected persons, it has come to light that the suspected, the present Ali Hussain, he has stored a huge number of contrabands in his house situated at Tupkuri, Pathar, Nagaon. So thereafter, lordship, after recording the ZD entry dated 22/09/21, the PW3, that is the OC, he has conducted search of the house of the accused persons as pended under section 42 of NDPS Act, along with two independent witnesses, there's PW1 and 2, who happens to be the BDP secretary and Gaon Vihar lordship, accompanying the PW3. And thereafter, they have searched the house of the premises of the petitioner and found 326 strips of paracetamol, dicyclomine hydrochloride, and tramadol hydrochloride tablets recovered and duly seized in accordance with in compliance with provisions 42 before the independent witness expression. And thereafter, Lordship, FIR has been lodged under section 22C of NDPS Act along with 29 of NDPS Act. Thereafter, during the course of investigation, inventory was prepared and police made representative samples of the CIS articles as per section 52A, and certification was obtained from the learned magistrate, and the samples were sent for examination to FSL. And as per FSL report, it gave positive test for tramadol, Lordship, which was found to be, which was in commercial quantity. So during the course of after investigation, Lordship, IO has recorded the statements of the independent witnesses, including the Caesar witness, PW 1, 2, and 3 is the OC, and 4, PW 4 is the scientific officer, Lordship. Thereafter, Lordship, after receiving an expert report from the FSL, Lordship, which gave positive test for tramadol, the CIS contrabands, charge has been filed against 4 persons, including the present petitioner under section 22C and 29 of NDPS Act. And thereafter, Lordship, charges were framed against the accused persons. And Lordship, so far as Lordship, my learned friend has stated that DD entry, the duplicate copy of the DD entry has been sent to the carbon copy of the ZD entry has been sent to the SP office. Usually, it is a by default, Lordship, that certified copies or carbon copy is always sent to the SP office, and there is no illegality and not complying the mandate, which is under section 42(2) of NDPS Act. It's purely duly complied with sections 42 and 40 because the carbon copy has already sent to SP office, Lordship. And thereafter, Lordship, my learned friend has after going through the marshalling the evidence of the prosecution witnesses, in spite of some minor discrepancies and due to some technical flaws on the part of the investigation, the material facts remain that the searches said commercial quantity is seized from the conscious possession of the petitioner, that is, from his premises, Lordship. And there is this chain of custody, Lordship, because section 55, section 42, which is duly complied with, and so far as section 55 is concerned, that requires the officer in charge of a police station to take charge and keep in safe custody all CIS articles under this act, which was duly seized and which was kept under his custody in compliance with section 55. And thereafter, samples were taken and sealed before the magistrate, Lordship. And PW3 being the officer in charge, he had testified that the police party has visited the house of the accused Ali Hussein at 11:30 p.m. And after the search and seizure, the police party departed at 12:45 a.m. and reached the police station at 1:05 a.m. And on reaching police station, he has kept his articles in police falkhana. And thereafter, on the next day, the seized articles were produced before the magistrate for certification of inventory. And that is duly done. And thereafter, also certification of inventory. It may be pointed out here that late in the night of 2021, that was on 22/09/21, contrabands were seized from the house of the accused person. And next morning, police made a prayer for certification of inventory. And 326 strips of 8 capsules, each of approximately meds pass. That is paracetamol, disoclomine, hydrochloride, and tramadol, hydrochloromycin capsules, which was weighted at 1,398.54 grams, Lordship. Thereafter, Lordship, As far as PW 1, 2, 3. PW 1 and 2 are concerned, also they are happens to be the independent witness. Their testimony is found to be reliable, consistent, and remain firm, Lordship, and the defense side has failed to demolish them on the material point that it was not seized from the conscious position of the additional appellant, although he was not present at that relevant point of time. Because there is, his house is identified by between 1 and 2, because they are the Gaunhuras and BDB persons, Lordship. And his locality is well known to those persons as PW 1 and 2, Lordship. And so far as the informant, who happens to be the OC PW 3, his person is found to be remain consistent to his version, and his testimony finds support from the certification of learned judicial magistrate done immediately after the seizure. The chain of custody has been proved and as much as there is no delay in producing the seized contrabands before the learned magistrate. The next day, they have produced the seized articles before the magistrate, Lordship. So there is no non-compliance of section 55, 42, 52A does not arise, Lordship. And other way also, as per section 35 of NDPS says, there is a presumption that the existence of culpable mental state, that is always there. So but that can be rebutted, which plea doesn't, the defense side doesn't take, Lordship, at the time of trial, Lordship. And so far as PW 1, 2, and 3 have remained consistent all along throughout the evidence, Lordship. The contraband was recovered from the house of accused Ali, which was found in conscious possession, and I have found no illegality in the order and judgment of the trial courts, who has rightly convicted the accused under section 22C of the NDPS. That's my humble submission.
Just one thing I'm pointing out before Lordship, that when we say that there in the NDPS Act is a stringent provision, Lordship, and therefore strict compliance of the provisions is required. And if your Lordship see the list of exhibits and the documents which are exhibited in the present case, even the GD entries which were referred by the investigating officer were not exhibited in the present case. Those GD entries, they are referring to GD entries, that these are the compliance, but they have not exhibited those GD entries. They have to exhibit it, that they have to show it that yes, strict compliance is there. It is their burden. Therefore, a suggestion was there that you have not followed the provisions of NDPS Act, because the Defense Council cannot teach the IO that you exhibit those. So a general suggestion was there that you have not followed the provisions of NDPS Act. It is the duty of the prosecution to show to exhibit those GD entries. That this is the GD entry, this is written here. Because why I'm placing it this, Lordship? Because the investigating officer said that the appellant was arrested. Appellant was an accused in Botodroba PS case number so and so. During cross, he said he do not know about the case. So how he is connected? There has to be seen. Without knowing anything, he is submitting before the court, Lordship. For that purpose, to ascertain the genuineness, all those things, the exhibition of that is required, Lordship. That defense should get an opportunity to cross-examine on that point. But they have not done. They have only said that this is a GD entry. By default, may it have gone to SP, but it has to be on record.
Otherwise, there are some, undoubtedly, there are some minor discrepancies and technical flaws are there on the part of the investigation. It does not discard the core issue that the contraband has been recovered from the conscious position of the present petitioner, because it is recovered from the premises where he used to stay. That is my humble submission.
Yeah, and DPS cases simple flaw of investigation that is fatal for prosecution. Obliged.
Well, give adjustment to that regard.
Regarding the flaws, I mean, the
Technical flaws on the
technical
part of
flaws.
the investigation. Later on,
If he submits to the
Later.
employers.
produce, Lordship.
Obliged.
Reserve waiter. Reserve, yes.
My lord, my learned
Right, hold it, yeah, they do. They do.
my learned friend has obtained the instruction, item 4, my lord.
Item?
The four, for the person, my lord. Actually, my lord, this case was registered under Dispur Police Station, my lord. But my lord, the informant, my lord, he is a resident of Sorthebari. So, my lord, as per the instruction of this honorable court, my lord, we try to serve notice, my lord, to Sorthebari Police Station, my lord.
Hmm.
And we have been informed that, my lord, there is no, my lord, the person is not available in the given address, my lord.
In Sorthebari also.
In that case, my lord, lordship may-
Jogen Boro, late Boro,
Village, my lord,
resident of village
Borgopa, my lord.
Borgopa. PS Sorthebari. This is the,
Please wait, my lord, for two occasions, my lord, but they could not.
any family members or any other, or he is not traceable or what?
So he is not available, my lord. That person is not available.
No, available, not available in his house, or no house is available, there's difference, no?
That we have been informed that no person is available, my lord, in the village of the body. That we have been informed.
You got the address from where?
my lord, from the record, my lord. Yes, if your lordship sees. Page 18, my lord. Rekha Boro, wife of Jugen Boro. House is at Moja, village, Borgopa.
No, this is the address of Jogen Boro also. Now, she is the informant victim. Who is she? Rekha Boro?
My lord, she is the wife.
She's the wife of Jogen Boro. Why don't you send the Rekha Boro should be the, I mean, she may be the proper person, I think, as a respondent number 2. Because there, she is the wife of one Jogen Boro. Okay, Rekha Boro lost the FIR, in fact.
The FIR, page 16, my lord.
Page 16.
16,
Page 16.
my lord.
16.
No, my lord, the question is that, my lord, if the, my lord, FIR is lost by Jugen Boro, my lord, his address is given, my lord, as a house number 12, my lord, Krishnanagar. Then, my lord, Krishnanagar, Zaporizhzhou, my lord. Then, my lord, why he has given his address, my lord? Jugen Boro, my lord, resident of village Borgopa, PS Sorthebari.
This was, my lord, the rented house. Krishnanagar. Japorigo. And
This person is also named as a witness in this
yes,
case.
my lord, he is at page 26, my lord. Jugen Boro. But nothing is, address is there. Address Kailipara, Dispur Police Station.
Another address, my lord.
Yes. My lord, my
Otherwise, your petition is to that is the you are you're challenging one order whereby your prayer was in fact rejected.
rejected
That is
order
the
for further cross-examination. My lord, the amicus curiae may be
Yeah,
appointed.
one amicus may be appointed. Otherwise, his address is so.
Yes,
I mean,
ma'am.
yes,
Correct.
There are three different addresses.
3 different
My lord.
addresses. So where he is now. And Rekha Boro is also a witness. No,
Rekha is the mother of the victim.
she's the mother of the
Yes.
victim.
In fact, my lord, if this petition is allowed also, they will not get prejudiced, my lord.
Anyway, we
Yes.
appointed.
Appoint
you
a
to
amicus,
hear
my
the
lord.
matter.
Appoint a amicus, my lord. Thereafter, your lordship will hear the matter.
You're in
My
item
submission-
number 4.
My lord.
My lord, my submission may be recorded, my lord, in spite of, my lord, your effort, my lord, the notice could not be served, my lord.
Yes. Heard Mr. S.K. Talupte, the learned counsel for the petitioner, and also heard Mr. Arjun Borwa, the learned additional PP, appearing on behalf of state respondent. It is informed by Mr. Borwa that on inquiry it is reported from the police, reported by the police, concerned police of, reported from the concerned police station that in spite of 4 attempts, this notice could not be served on the respondent number 2. as he is not available in the address given in the notice. On inquiry in the record, it is also seen that the said person, namely Jugen Boro, had given 3 different addresses in 3 different stages of this case. Stages of this case, first of all. This, considering the entire aspects of the case, it is this court is of opinion that one amicus may be appointed to represent the respondent number 2, so that the matter may be heard on the next date of listing.
Respondent number 1, my lord.
So
Two
it's
is
the
state.
respondent number 1,
My lord. 2 is the
not
state.
1, 2.
My lord.
State is 1, I think.
State is 2, my lord. Respondent
is
number
2.
1 is the, my lord, informant.
1.
1. Jugen Boro.
So what a 1 for it, 1 to back up to us. The registry will appoint or us. Registry will accordingly appoint an amicus to represent the respondent number 1. And matter may be listed for in admission column then. next
Admission
one.
column, my lord, may I pray the matter is, lower court matter is fixed on 4th. Before that, lordship will kindly.
4th of?
January, my lord.
Before that, we don't have any. We don't have any date.
It will
That is
hardly
the
take, my
problem.
lord, 10, 15
Whatever,
minutes.
we don't
Madam.
have any date. That is the prior. 4th will be prior vacation. We don't have any date prior vacation.
4th will not be prior vacation, after vacation, my lord. 4th will be after
Immediately
vacation.
after reopening, my lord. No, 4th is, my lord,
Mm.
Saturday, my lord. 4th cannot be, my lord.
No, no, 4th to over,
আচ্ছা,
4th
lower
Saturday, tate ase.
আচ্ছা, আচ্ছা, আচ্ছা।
Third, if it
Third.
is third also, I don't know.
My lord, may I take the chance, my lord, lordship may list on, my lord, it may come
Okay,
on list,
third,
my-
third.
3rd of January.
Third of February.
Deeply aware.
Item 7 for hearing.
About ourselves, I think.
Maybe
I understand it is probably difficult. I'm saying they are here. Huh? Okay. Yes, yes. Okay. Item number 7.
Lordship, the applicant was died on 29/5/2018 and
When he died?
29/5/2018.
29/5/18.
Yes, Lordship.
Your appeal is of 2017.
Yes, Lordship. And as
So
per
why
order,
the matter was listed on several occasions, I think. Oh no. Anyway.
Right.
This is the third occasion. It is listed on last. It was listed on 4/8/2017, and then on 21/11/2022.
yes, Lordship. And as per that order,
You have filed your death certificate now.
Lordship, we could not collect that certificate as the appellant is died.
No, appellant died. Have you collected the death
We
certificate?
could not contact with them.
Then what to do? Police report to be called for?
Yes, my lord, that police report would go for to registry, my lord.
To registry, yes.
Registry.
URMS?
Yes, Ahmed.
S. Ahmed. Heard it S. Ahmed. The learned counsel for the appellant and also heard Mr. Ajiporo, the learned additional people. It is submitted by MS Ahmed that the appellant died on 29/5/2018 and in pursuant to order dated 21/11/2022. The
Report has
the
been
council tried, the learned and this council tried to get a copy of the death certificate, but they could not contact the appellant side till that. In view of this, let a date report be called for from the concerned police station.
Lordship, reports are called for the police station.
Huh?
Reports have been already called
By which order?
on 21/11.
Which order?
21/11.
21/11, my lord.
No. Call for a report from Acha.
Yes, reports have been called, but the death certificate could not be collected from us.
Report we have received. Yeah, I don't actually understand.
Have to go.
Why is it at all?
It's been called.
I will go back to control center, back, flag attaching is. This is. আগৰ লাইনটোলৈকে কি আছিল আপোনাৰ? They could not contact to file. No, V2 আগৰটো। বাকীখিনি কাটি দিম, ভিউটো কাটি দিম। However, then what to do on basis of this one only? Date report is here,
That report is there, on the basis of that report, my lord.
will be abated.
Abated.
But however, from the record, it is seen that the date report has already been collected by the registry from officer in charge, Ram Nathpur Police Station, Hailakandi. Wherein also it is reported that the appellant, namely, what was his name? Jahiruddin. Jahiruddin Laskar, son of Nizamuddin Laskar of Dariyar Ghatli, DARI. Sailoba, yeah, green market as it is also green. So and so. Okay, understood. Died on 29/5/2018 at so and so under Ramnathpur Police Station. Considering the report of submitted by the officer in charge Ramnathpur Police Station, the present appeal stands abated on the date of the appellant. But is there any other person to continue the appeal and all?
No, for that reason, my lord, they have to file an application, my lord. As per the.
Do you have any such instruction, any such? To continue the appeal? Then we'll make the liberty will be there then.
Provided there will be some time limit, my lord. P94, my lord. To CRPC,
What it says?
My lord, 394, my lord, I am reading the provided, my lord. Provided that where the appeal is against a conviction and sentence of death or of imprisonment and the appellant dies during the pendency of the appeal, any of his near relatives may, within 30 days of death of the appellant, my lord, will have to apply, my lord. If they have applied, my lord, within 30 days of the pendency of the appeal, my lord, then it will remain, my lord.
I don't know where the knowledge was there.
It is their duty, my lord.
Their
Perhaps, my lord.
Can it be any order for option, liberty can be given or?
No, my lord, that will be time barred then, my lord. As per the section 34 of the, my lord, CRPC.
Yes, obviously.
It will be time barred.
Abated, stands abated. If you have any instruction, if someone continue, then you may file a fresh with some liberty.
And my lord, they have to file a leave application, my lord. And if the leave is granted, then only they.
Then only then.
Appeal may be granted.
Otherwise, presently it is abated, and thereafter, if it is some disposed of.
Time being 20 for being hearing.
Yeah, please, Lordship. Lot 483 of BNS's petition. Lord, the petitioner is behind the bar for last 505 days. That is almost 17 months. My lord, the matter relates to section 25, read with section 22C of the NDPS Act. My lord. So, my lord, case has been charge sheeted, my lord, till filing of the instant bail application 3 PWs were examined, and later on, I have collected one evidence has been, statement has been collected by me. That is the PW4.
One more.
One more, my lord. PW4. He is the seizing officer, my lord, come informant of this case. And if we go through the statement of the PW4, it would be very much clear. My lord, I am the owner of the Bolero pickup, where from the 5,075 bottles of penicillin cough syrup was recovered, and it was driven by the driver Shahidul Islam. He was also arrested. And after recovery of the said contraband, I being the owner, I was arrested after 64 days of the said recovery, my lord. Along with the said driver Shahidul Islam, 2 more accused were also arrested. And those 2 accused persons have been discharged by the learned trial court. As because they were arrested in another car. They were boarding in another car, Swift Desire car. But the contraband was recovered from the Bolero pickup. And in the Bolero pickup, only the driver Shahidul Islam was available. Now, I have collected the copy of the PW4. Just I'm relying 2-3 lines, my lord. In page number 2, we intercepted the vehicles. The Swift Desire car was being driven by one Basiruddin.
Just a second. You have the PW4, Mr. Bora?
Yes, madam.
PW4 is here. Okay. Yes, you can see.
The Swift Desire car was being driven by one Basiruddin, and there was another person inside that car by name Abdul Rashid. These 2 persons have been discharged by the learned trial court. Shahidul Islam was driving the Bolero pickup vehicle. There was none present inside the Bolero pickup vehicle except Shahidul Islam. That means driver was alone.
No, you are the owner of.
I am the
vehicle.
owner of the Bolero pickup. My lord. Now in cross part, page number 5, very much clear. I am accused Ainul Haq. Page number 5 in cross, the PW4 stated
My
accused.
lord, I have one objection, my lord. This is a bail application, my lord, where the search that case, my lord, trial is going on. At least as my lord, this honorable court will not appreciate the evidence, my lord, what has been recorded before the trial court, my lord.
That is another.
Because, my lord, if lordship will pass any order, my lord, assuming my lord, lordship allows his bail application or reject his bail application, it will hamper the trial, my lord. Because he is, my lord, referring to the, my lord, evidence laid down before a trial, my lord. Trial is not completed, my lord.
My lord, my submission.
Most probably he wants to say that because 37 speaks of 2 ways,
My
that if there is any reasonable belief that he has not committed any offense.
My
So
lord,
in that regard, he wants to
My
submit
lord.
on merit.
The question is that, my lord, as far as my lord, section 37 is concerned, my lord, in case of commercial quantity, my lord, recovery is not signed qua non, my lord.
You
It is
can
not-
submit
it
on
is-
this.
Yes, it is not required that, my lord, recovery has to be made from that person, my lord. If he is the party of the, my lord, offense, my lord,
Obviously.
then also, my lord, he is liable, my lord.
My lord, that is
Very
why I'm
obvious.
submitting that whether the recovery was made from my possession or not.
He is submitted the recovery from your position may not be there, but whether you are
I'm-
constructive position was there.
I am coming on that point, my lord. That from this point.
So now you want to say the driver was alone in the car?
Yes,
There was
my
no
lord,
other.
that has been asserted by the PW4.
So obviously, he
seizing
was
officer.
there, yes.
My lord. Now I am
No
coming.
question about it.
Then why I have been arrested?
Why?
Then why? The driver accused Shahidul. He had reported to the seizing officer that the accused owner of the vehicle is also known to the fact. Only this much he has stated. His statement I have already enclosed along with my bail application, my lord. Page number 42. Last 5 lines, ma'am, my lord. Page number 42, last 5 lines. The owner of Bolero vehicle, Ainul Haq, myself, that is, of Helapakri, and knows these illegal activities. And the whole trafficking was controlled and owned by one Ilyas of Karbala. So, my lord, I am analog. This much allegation against me by the co-accused, from whose possession the contraband were recovered. My lord, now I am coming whether the statement of the co-accused is admissible evidence. But in this regard, I would like to draw the kind attention of this honorable court to a decision rendered by the Honorable Supreme Court in Tufan Singh as well as in Bharat Chaudhary. As well as in our Honorable High Court, that is first in Criminal Appeal 198 2015, Rameshwar Kakoti and others versus State of Assam and another. My lord, I am submitting the copy. In Bharat Chaudhary, page number 5, para 5, para 5, 10, and 11. Para 5, married. Being mindful of the recent verdict of a three-judge bench of this court in Tufan Singh versus State of Madras, wherein as per the majority decision, a confessional statement recorded under Section 67 of the NDPS Act has been held to be inadmissible in the trial of an offence under the NDPS Act. In paragraph 10, now coming to paragraph 10. After carefully examining the arguments advanced by learned counsel for the parties and having cursorily glanced at the records, we are of the opinion that the impugned order cancelling the bail granted in favor of Bharat Chaudhary, accused for, is not sustainable in view of the fact that the records have to be relied upon by the prosecution show that one test report dated so-and-so, two test report dated so-and-so, and one test report dated so-and-so in respect of the sample tablets drawn and sent for testing by the prosecution agency. This is not relevant. Next page, not relevant. Next page, paragraph 9. Most importantly, none of the tablets were seized by the prosecution during the course of the search conducted either at the office or at the residence of accused 4 at Jaipur. Next paragraph 11. In the absence of any psychotropic substance found in the conscious possession of accused 4, we are of the opinion that mere reliance on the statement made by accused number 1 to accused number 3 under Section 67 of the NDPS Act is too tenuous a ground to sustain the impugned order dated so-and-so. This is all the more so when such a reliance runs contrary to the ruling of Tufan Singh. This is the decided in Bharat Chaudhary. Now I am coming to the next decision, my lord, in past in Rameshwar Kakoti. Paragraph 52. Paragraph 52. Last page, my lord. Last page. Second line. Law is well settled that any confession made by the accused person during the course of investigation and while in police custody would be inadmissible evidence. The IO has evidently not got the confessional statement of any of the accused persons recorded before the magistrate under Section 164 CRPC, and there is no explanation as to why the same was not done. The fact that the IO had deposed before the court as regards the alleged confession of the accused persons pertaining to the conspiracy theory, as noticed above, not being evidence admissible in law and in the absence of any other evidence available on record to corroborate the IO as regards the complicity of the acquitted accused persons, we do not see any good ground to reverse the finding of the learned trial court insofar as the acquittal of the 5 accused persons is concerned. So my submission is that, Your Honor, that the merely on the basis of the statement of the co-accused, he cannot be kept behind bar for last 17 months, my lord. Discharge petition was also filed before the learned trial court. That also has been dismissed, my lord. And the charges under section
So how many witnesses are there, listed witness?
12 witnesses in that. My lord, in charge sheet, 12 witnesses. Total 12 witnesses. Out of 12, only 4 witnesses have been examined, my lord. The case is charge sheet was filed on 7/11/2023, my lord. And the charge framed on 6/3/2024. Almost the petitioner has been behind the bar for last 17 months. Then another 8 witnesses remain to be examined, my lord. So it will take much more time, my lord. That in this regard, I would like to refer the decision of the Honorable Apex Court, my lord. Javed Ghulam Nabi Sheikh, my lord. This is Article 21 is the violative of Article 21. I am relying. One more aspect I have to clear, my lord. That is the Section 25 of the NDPS Act, my lord. That is the convention, knowingly, whether the contraband was recovered and from my possession, that was not my possession. But whether
That is
I
why
was
25 is there.
25 is there only because that word is there, my lord, knowingly.
Yes, you know.
That means I know.
That means you know
I
that
know.
the contraband was loaded in your vehicle.
Vehicle, my lord. But in this regard, my lord, I would like.
Sometimes it happens that contraband is found in your house, knowing that you know that the contraband
My
is
lord,
there.
that is
25.
that is section 25, my lord. But in this case, my lord, I would like to refer a decision rendered by the Honorable Supreme Court in Bhola Singh case. Bhola Singh case, my lord. I am also supplying this copy. Bhola Singh case, very much clear, my lord. Very much clear. Paragraph number 8. Paragraph number 8. We have considered the arguments advanced by the learned counsel. We see that section 25 of the Act would not be applicable in the present case as there is no evidence to indicate that Bhola Singh, the appellant, had either knowingly permitted the use of the vehicle for any improper purpose. The sine qua non for the applicability of section 25 of the Act is thus not made out. Now, I am coming to the next paragraph 11, madam. Applying the facts of the present case to the cited one, it is apparent that the initial burden to prove that the appellant had the knowledge that the vehicle he owned was being used for transporting narcotics still lay on the prosecution, as would be clear from the word knowingly. And it was only after the evidence proved beyond reasonable doubt that he had the knowledge would the presumption under section 35 arise. So merely my vehicle was used by the driver. I have submitted in my petition, my lord, that the owner of the truck, the petitioner, is a tailor by profession, and he used to let his vehicle on hire to various drivers. So on the previous day of the alleged incident, my lord, the driver Shohidul Islam took the vehicle of the petitioner, saying that he has a trip to Meghalaya, cement trip, my lord, saying that he has cement trip, and accordingly this vehicle he had taken. Next day, the petitioner came to know that the vehicle has been intercepted by police. So this my submission, my lord. The petitioner is behind the bar. So the other witnesses concerned, they have not supported the case, prosecution case. So he is behind the bar for 17 months, my lord. Considered him.
My lord, out of my lord 12 prosecution witnesses, my lord, 4 witnesses have been examined as on date, my lord. Last PW4 was examined on 25/7/2024, my lord. PW4, my lord, he is a, my lord, investigating officer, my lord, IO, my lord. I'm sorry, informant, my lord. Now, my lord, other 3 witnesses, my lord, they are seizure, my lord. Seizure witnesses. But admittedly, my lord, the recovery has not been made from the possession of the present petitioner, my lord. He is the owner of the vehicle. And my lord, what is the allegation against him, my lord? Lordship may kindly come to my lord, page number 27 of the bail application.
Yes.
That forwarding report, my lord, I'm sorry. Not page 24, my lord. Forwarding report, my lord, page number 20 and 21, my lord. Lordship may kindly come to page number 21. Page number 21, my lord. They also mentioned that the owner of Bolero vehicle, Ainal, mobile number so and so, knows these illegal activities, and the whole trafficking was controlled and owned by my lord, Elias, my lord. Mobile number given, my lord. That is why my lord, section 29 has also been added, my lord. And other 2 persons, my lord, who were also arrested, and as per my learned friend submission, my lord, they were my lord, discharged, my lord, at the time of framing charge, my lord. Because they were also, my lord, apprehended, but they were in a different car, my lord. They were in a different car. They were not in the same car, my lord. They were in a different car and nothing was seized, my lord, and nobody has implicated him. That is why, my lord, they were discharged, my lord. But in this case, driver has been apprehended, my lord, and the owner of the vehicle, my lord, it is in his personal knowledge, my lord. The contraband is carried, my lord, in his vehicle, my lord. So at this stage, my lord, I am opposing because out of the 12 witnesses, only 4 witnesses have been examined, my lord. Remaining witnesses are yet to be examined. And my lord, section 37 will come, my lord, rigors of section 37. Because those who will draw satisfaction that, my lord, there is no material to convict the accused person, my lord. And secondly, my lord, after releasing him on bail, my lord, he will not commit the same offense, my lord. That satisfaction, lordship will have to draw, my lord, at the event of, my lord, enlarging him on bail, my lord.
My lord, where
So at
there
this
is,
stage, my lord, I am opposing, my lord. And my lord, secondly, my lord, Tufan Singh, my lord. What has Tufan Singh said, my lord? Confessional statement made to the police officer would be barred under the provision of section 25 of the Evidence Act and cannot be taken into account in order to convict an accused under the NTPS Act, my lord. On the basis of confessional statement of a co-accused, my lord, a person cannot be convicted. That is the, my lord, law laid down in the my lord, Tufan Singh case, my lord. But in Tufan Singh case, it is nowhere stated. On the basis of a, my lord, co-accused statement, a person cannot be arrested. A person cannot be put into trial, my lord. Because it's all organized crime, my lord. My lord, the kingpin, my lord, they never get arrested, my lord. Only the peddlers and other person they arrested, my lord. So at this stage, my lord, I am opposing, my lord.
Twenty-one. Yes.
Victim will already been examined, lordship.
Victim already examined.
Informant is also examined.
He is custody since last 1 year.
Since almost 1 year, lordship, arrested on 26/12/23. And earlier he was on bail, then later on he could not appear, then on the strength of NBW and PNA, he arrested again, lordship, 26/12/2023. Till then he was in custody.
How many witnesses are already been examined?
Out of 11, my lord, 3 witnesses are given.
Victim, informant, and 1 independent witnesses.
Victim is of very minor or
Victim, my lord, she is aged about 14 years at the time of incident. informant yet to examine, my lord. Victim and two other witnesses examined, my lord. They are not informant, my lord.
Informant is mother, brother, who is he?
Mother,
Father,
father, my lord.
Father.
father of the victim.
Yes.
My lord, the informant also appeared, my lord. Her name.
Oh, where is the informant?
Okto, my lord. 21, my lord. C. Kolita. This C. Kolita appeared.
Yes, C. Kolita. I have seen C. Kolita. In the morning hours, she was there?
I have not found, my lord. So let her appear, my lord, because otherwise, my lord, without her absence.
Lordship already more than 11 months, Lordship, and earlier, he was being bail, Lordship. And due to some miscommunication with the.
That is the main concern. In fact, he wasn't bail,
Yes.
but he jumped over the conditions of the bail and he absconded. As to that is why NBW and PNA had to be issued against him. Thereafter only he got arrested. As you have submitted, I have not gone through the case record. So his conduct is not so good.
Almost 1 year, Lordship, kindly, Lordship.
Obviously, that is expected. Let her come. Again, it will be timing or what? Is there any way to inform her?
I do not have any, do not have her phone number, my lord. What phone number?
Do you have?
No, Lordship. Morning time, she was also absent.
Whether they have filed any objection here? No.
That I have not found.
No, listen again. Not here, I think. I mean, she's not an amicus.
No, my lord, she has been appointed.
Appointed.
She has been, my lord, engaged by the, my lord, my informant.
Informant. In that case, her presence is required, in fact. We don't have any means to, I mean, way to inform her, in fact. Do we have any? No. Hmm? I have recorded your submission, that is with us. And what is your submission?
My submission, my lord, PW1 victim, she is implicated.
Implicated.
This started that case, my lord, and trial is going on. And conduct with the accused person, lordship is already noted, my lord. Conduct with the accused person.
No. No.
If litigation exists, the next step may be reviewed and she will be excited.
Is what to do then?
My humble submission, my lord.
Because she, otherwise, if the court, sometimes it happens that amicus be appointed by, so amicus will be definitely submit on the basis of the record. But once she's been engaged by the party concerned, so obviously she may have the other information also that we are not in a position to say anything.
Lordship, immediately after vacation.
We don't know.
It's very good, so 20, my lord, 20 is it.
And next date, do you know where is the next date? No idea. Two zero. January will do, 20th of January, otherwise before vacation, we don't have time. in fact. Matter could not be heard due to absence of the engaged council MSc Kalita for the response number 2. As your scan copy of the LCR has already been received. Data present status report be called for. Registry will do the needful. List the matter accordingly on 20 Wednesday.
Thank you, 22.
Yes, yes.
This matter relates to the prayer for bail under section 483 of the BNSS by driver and handyman of a truck who are carrying some goods. And my lord, during Naga checking at Bajarichera police station on 21/1/23, allegedly recovered, my lord, fentanyl in the same truck under the other goods matters. Accordingly, police arrested them, and today is 670 days, my lord, behind the bar. So, my lord, case was subsequently charge sheeted, and there are showing 9 witnesses are to be examined. My lord, chronologically, I have given the status of the case. You will find that FIR is at Annexure 1, my lord. Kindly peruse the, if your lordship wants to peruse the FIR, that is what I have submitted, that it was recovered, allegedly recovered from the truck, page 21, is the FIR lodged by the sub-inspector Niranjan Das against these 2 persons, driver and handyman. Then, my lord, they were forwarded to the court next day in the same, before the court.
Date?
Yes.
Which date?
Date is, my lord, on 1 minute. 22/1/2023. Then, my lord, case was charge sheeted, my lord, against them, showing the 9 person as witness, my lord. And during course of the order, my lord, you will also find case was fixed for evidence, my lord, after framing the charge, which was denied by them. First witness was, my lord, fixed for evidence was, my lord, 3/10/23. But no witness was examined, 3/10/23. Thereafter, on date was fixed on 30/11/23 for evidence of the prosecution witness. Turned out as no summons was returned, so no witness was examined. Then again it was fixed on 8/2/24. The prosecution witness, 2 witnesses were turned, namely Badri Narayan and Sanjit Ravidas, but they were not examined by the court, my lord. That is on 8/2/24. Thereafter, Annexure 9 you will get in. On the same day, another witness was summoned, named by returned after service, but no report was witnessed or received absent. Then on 2/4/24, prosecution witness turned up out of the witnesses who's allowed to go on peer bail, not examined, my lord, again. Then when Annexure 12, you will find that order. Then I take your lordship, the order sheet dated 17/5/24. No prosecution witness turned out, and again, learned session judge, special judge, passed an order, issue summons to the witnesses again, fixing 1/7/24 for evidence. On 1/7/24, no prosecution witness turned up, passed an order to issue fresh summons
fixed in 2/8/24. On 2/8/24, prosecution has projected witnesses Sanjit Rovidas and Bodhinarayan Gwala as the seated witness. Sanjit Das has appeared and examined as PW1. Police witness R.K. Vikram Singh also turned up, but said witness was not examined. Bodhinarayan Samun returned with the report that he is out of station. Then, my lord, prosecution witness number 1, Sanjit Das, had stated that he has not stated before the police that, and he improved this story and during cross-examination, his vital improvement was that he confronted, and even he has stated that in cross-examination that he has signed on the seizure list, but he cannot say what police has written. Moreover, he is a stock witness for the police. Stock money means regularly he is giving witness in many cases. Then, my lord, thereafter in the charge sheet, prosecution has just cited 9 witnesses. Till today, only 1 witness was examined, madam. And rest is still it is pending for further evidence. Now, my lord, in the meantime, 570 days I have already completed, my lord. 670 days behind the bar, my lord. Now, in a similar case, my morning, your lordship has heard one argument, my lord. I have observed, my lord. Now, one after another, my lord, I have got the similar judgment, my lord. I am giving one Supreme Court judgment, my lord. Kindly, please go to attack of the one. Attack of the one. My lord, in this Supreme Court judgment, this is 2024, my lord, judgment. My lord, your lordship, I take your lordship to para 9, my lord. Para 9 of the judgment. By order dated 16/7/2016, the trial court framed the charge against the appellant under the aforesaid provisions of who pleaded not guilty. Thereafter, the trial issued summons to the prosecution witnesses. Then, my lord, I take your lordship para 16. On the other hand, the Gorima Prasad, learned additional Advocate General of the state, if you submit that the charges against the appellants are very serious in nature. Besides, his being the foreign national, there is an attendant flight risk. Therefore, the appellant may not be released on bail. Instead of the trial court may be directed to expedite the trial. Referring to the counter affidavit filed on behalf of the state of UP, she submits that appellant is an accused of under UAP Act, therefore not entitled to bail. In this connection, she has referred to a recent decision of the Gurinder Singh versus State of Punjab. Then, my lord, I take your lordship para 19. As already noted above, appellant is custody for more than 9 years now. That is the case of 9 years. The impugn orders says that evidence of only 2 witnesses have been recorded in 9 years. In such circumstances, a reasonable view can be taken that trial is likely to take considerable time. Before proceeding further, let us briefly look into the sections invoked against the appellant. Section 489 BIPC deals with the offense using forged or counterfeit currency notes, bank notes as genuine despite.
These are not required, I think.
Then, my lord, para 21, what is the findings? It is true that appellant is facing charges under section 489 BIPC under section 16 of the UAP Act, which carries a maximum sentence of life imprisonment. If convicted, on the other hand, the maximum sentence of section 489 is 7 years. But as noticed above, the trial is proceeding at a snail pace. As per the impugn order, only 2 witnesses have been examined. Thus, it is evident that the trial would not be concluded in the near future. Then, para 23, the bench in a recent decision of dated 3/7/24 in a Javed Ghulam Nabi Sheikh versus State of Maharashtra, criminal appeal number has held that however serious of the crime may be, an accused has the right to speedy trial under the Constitution of India. That was also a case where fake counterfeit Indian currency notes were seized from the accused appellant. He was investigated by the National Investigation Agency under the National Investigation Agency Act 2008 and was charged under the UAP Act along with the 489B, 489CI. He was in custody for under trial prisoner for more than 4 years. 4 years. And trial court had not even framed the charges. It was the context of the court to believe that over a period of time, the trial court has high courts have forgotten the very old well-settled principle of law that bail is not the withheld of the punishment. Then, my lord, there are 24, my lord. Earlier, the Supreme Court Legal Aid Committee versus the Union of India, the court had issued the notice, slew of the directions relating to the under trial to jail, facing charges under Narcotic Drugs and Psychotropic Substance Act for a period exceeding 2 years. It's very important. That is the order of Supreme Court. Exceeding 2 years on account of the delay in disposal of the cases lodged against them. In respect of the under trial, who were foreigners, the court directed that the special judge should impound their passport, besides insisting on a certificate of issuance from the Consular Embassy High Commission of the country to which the foreigners accused belong to. Such accused should not leave the country and should appear before the special court as required. Similarly, in Shaheen Welfare Association with the Union of India, the court is considering the public interest litigation wherein certain reliefs were sought for under trial prisoners charged with the offence under Section Terrorist and Disruptive Activities Act, languishing in the jail for a considerable period of time. This court observed that while liberty of a citizen must be jealously safeguarded by the courts, but at the same time, in the context of stringent laws of TADA Act, interest of the victims and the collective interest of the community should also be lost sight. While balancing the competing interests, the court observed that the ultimate justification for the deprivation of liberty of an under trial can only be on account of the accused under trial being found guilty of the offence for which the charged and is being tried. In such a finding is not likely to be arrived in within a reasonable time, becomes necessary. Therefore, pragmatic approach is required. Angela Harris versus State of Maharashtra is a case where the accused appellant was charged under various provisions of UAP Act as well as under IPC. He sought for this bail. The court observed that undoubtedly the charges are serious, but the seriousness of the charge will have to be balanced with the certain other facts like the period of custody suffered, likely period within which the trial can be expected to be completed. In that case, it was found that the appellant accused was in custody since April 2011, that is for over 5 years. The trial was yet to commence. A large number of witnesses who were supposed to be examined. It was in that context the appellant accused directed to be released on bail. Moreover, recently the judge, three-judge bench of this Union of India versus K. Nazib considered the appeal filed by the Union of India through National Investigation Agency against the order passed by the High Court Kerala, granting bail to the accused under trial facing trial for allegedly committing offence against others under Section 16, 18, 18B, 19, 20, 20. The court noted that the appellant of Najib was in jail for more than 5 years. Charges were framed on the 27/11/20. There were 276 witnesses still left to be examined. This court emphasized that the liberty granted to Part 3 of the Constitution of India would overthen in protective ambit, not only for due procedure and fairness, but also access to justice and speedy trial. No under trial can be detained indefinitely pending trial. Once it is obvious that the timely trial would not be possible and the accused has suffered incarceration for a significant period of time. Para 28 minutes. We therefore respectfully agreement with the reasoning given by the K. Najib regarding the decision of Jahar Ahmed versus Shah Wantali. The decision of Jahar Ahmed and Shah Wantali has to be read, understood to the context that which is rendered not a precedent to deny bail to an accused under trial suffering long incarceration with no end of sight of the criminal trial. So ultimately, bail was considered and granted bail in the NDPS case. This is the NDPS case. So, lastly, I take your lordship, Para 29, declining and interfering with the order of the High Court, K. Nazib, Union of India. Recently, this court shall dealt with the matter where the appellant, a foreign national, is being prosecuted for the offence punishable under Section 8, 22, 23, 29 NDPS Act. The appellant was arrested on 21/1/2014. The High Court has granted bail to the appellant by order dated 31/5/22, but had incorporated certain conditions into the bail order because which appellant remain in custody despite of having bail order in his favor. One of the conditions was that the appellant, a Nigerian national, should obtain a certificate of assurance from the High Commission of Nigeria to the effect that the appellant would not leave the country and would appear before the trial court on the date fixed. Another condition was also that the accused should drop a pin on the Google Map to Google Map in the ensure that the location of the available of the investigation officer at all times. So my lord, lastly, my lord, para 30, therefore the code is follows, we are dealing with the case of accused whose guilt is yet to be established. So long as he is not yet had guilty, the presumption of innocence is applicable. He cannot be deprived of all his rights granted under Article 21. Court must show restraint while imposing bail condition. Therefore, while granting bail, the court can curtail the freedom of the accused only to the extent required for imposing the bail conditions warranted by law. Bail condition cannot be so onerous.
These are all on bail
Yes.
condition.
So, my lord, this is the guideline that I have given to your lordship, my lord. Then I take your lordship, my lord. Our own High Court has granted bail, my lord, in a similar NDPS case, my lord. He is Asabuddin. Asabuddin. Duty question is what? My lord. It was my coordinated bench of this High Court, my lord. I take your lordship very at the earliest, para 7, my lord. Para 7 of judgment. The learned court for the petitioner has also submitted that though the instant case has been raised under Section 22C of the NDPS Act for possession of the commercial quantity of the contraband by the petitioner, however, regards of Section 37 of NDPS Act 1985 cannot abridge the right of life and personal liberty to which the person is entitled to under Article 21 of the Constitution of India, and this regard, learned counsel for the petitioner has cited the ruling Honorable Supreme Court, Muhammad Muslim versus Hoshan versus State and City, 23 SCC online. A plain and literal interpretation of the condition under the Section 37 would effectively exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special condition as enacted under Section 37 can be considered within the constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record that the accused is not guilty. On any other interpretation would result in complete denial of the bail to a person accused of offense such as this enacted under Section 37 of the NDPS Act. The standard to be considered, therefore, is one where the court would look at the material in a broad manner and reasonably see whether the accused guilt may be proved. The judgments of the court have therefore emphasized that the satisfaction which court are expected to record that the accused may not be guilty is only prima facie based on a reasonable reading, which does not call for meticulous examinations of the material collected during the investigation. Grant of bail on the ground of undue delay in trial cannot be said to be fettered by the Section 37 Act, given the imperative section of 436A, which is applicable to offence under Section NDPS Act. And having regard to these factors, the court is of the opinion that the facts of this case, the appellant deserves to be granted enlarged on bail. The learned counsel for the petitioner also cited the ruling of Supreme Court of Ravi Prakash versus State of Odisha. They observed that prolonged implication and generally militates against the most precious fundamental rights granted under Article 21 of the Constitution. And in such situation, the conditional liberty must be override statutory embargo created under Section 37(1)(b) NDPS Act. Then, my lord, I take your lordship para 12, my lord. Though this case involved commercial quantity, exactly in my case, here our case is, my lord, fancy deal was found. It appears applicable to the instance. However, the present petitioner is detained here, my lord. Our case, my lord, was from 670 days, my lord. That is more than almost 2 years, my lord. Yet they complete this trial, my lord. I take your lecture, the next page, my lord. Muhammad Muslim versus Hossain versus State of NCT. The grant of bail on ground of undue delay in trial cannot be said to be fettered under Section 37 of the Act. Ravi Prakash versus State of Odisha. Prolonged inquisition generally militates against the most precious fundamental rights granted under Article 21 of the Constitution. And as such situation, the conditional liberty must be override the statutory. Sariful Islam versus Sharif of the state of West Bengal, the same thing. Adhikari was the state of West Bengal, same opinion. Then lastly, para 13, in view of the above, petitioner named Asabuddin is hereby allowed to be released on bail of rupees 50,000. Then I take your lordship another judgment. Rashid Mallet, a also coordinate bank Mallet. Coordinate bank, para 5, I take your lordship. Para 5 Mallet. The learned counsel for the petitioner has also submitted that though the instant case has been registered under section 22C, similar case, the possession for commercial quantity of contraband by the petitioner, however, regards of section 37 of the Act cannot abridge the right of the life. The Muhammad Muslim
Same observation.
We are same case, my lord. Almost all the judgments are same opinion, my lord. Then Harish Mia, I am giving my another case, my lord. Harish Mia, our coordinate bench. Here also I have indication the para, my lord, 9, 10, 12, my lord. You also will get it. Kindly peruse it, 9, 10, 12. Then Nasiruddin, my lord, our coordinate bench. Here also I have given para. Here also, my lord, case was commercial, my lord. A bail of 1 lakh rupees was granted, my lord. Nasiruddin. Then lastly, Muhabur Rahman. It would be. Yeah, Nasir Rahman, my lord, the coordinated bench judgment, my lord Justice Thakur. Here also his lordship was given. The out of 11 witnesses, 6 were examined, my lord. In my case, only 1 was examined in last 2 years, madam. So 6 were examined. The aforesaid contraband amounts to commercial quantity under section, and the accused petitioner are in judicial custody for 682 days. In my case, 670 days. So, in the same parlance, my lord. Lastly, my lord, Lutfur Rahman, my lord. Lutfur Rahman, para 11, I take you. Our High Court has findings, sir. It is based, all the judgments will you should find based on the apex court judgment, one after another. I have not brought those judgments because all this are before your knowledge, my lord. Then morning also my friend has brought to your lordship knowledge all these judgments. So, my lord, I am ready to face the trial. It is the allegation of that, but only the sole witness who has been examined, he said that I have not seen what was the seized, but I was asked to sign. I signed them. So, my lord, he is behind the bar almost 670 days. Considering any condition, I pray your lordship with the folded palm, my lord. His case will be considered, my lord. Otherwise, to examine another 9, 7, 8 witnesses out of 9, it will take another 2-3 years. The problem is that most of the witnesses are police, CRPF or BSF, border, and they are posted in different parts of the country. That is, I appreciate that view. Usually they get someone that they're reluctant to come. Then unless there are so many formalities, they have to take sanction from the department, have to take advance from the department to travel up to this position. So, all these things cause a delay. I don't blame the prosecution that always they are delaying the matter. But some circumstances are there, beyond their control, that even if they are sending the summons time after another, but it comes back that report that man is not available. It is out of station, he has transferred. So all these things have to be considered because it will again prolong the delay, trial matter. That's why I pray that kindly consider the bail matter under any condition. This is my humble submission to your lordship.
My lord, as per my last order, my lord, in this case, my lord, after the status report was called for, my lord, and I have, my lord, perused the order sheet, my lord, but after the status report has not been received, my lord. Secondly, my lord, this witness, my lord, he was examined on 2/8/2024, my lord. PW1, my lord. After that, my lord, 4 months has been passed.
Do you have any status?
My lord,
Case status?
Next date is, I think, next date is in the month of January, my lord.
No, case status, whether any other witnesses?
No, not yet. I have talked to this morning also. No, not with this. Hey, your lordship may call for the status report. We can wait for that.
But the status is
Your lordship satisfaction is required, madam, definitely.
because my
No, otherwise you have a status report that if no other witnesses is already not examined yet, other witnesses.
Yes.
That is your version, but yes.
Yeah,
Purva, but-
the information,
Yes,
status may come
No,
up.
my lord, I have perused the order sheet, my lord. That order sheet, status report was called for, my lord.
Yes.
But the status, uploaded status report has not received, my lord. Now, my humble submission is that, my lord, PW1 was examined on 2/8/2024. After that, 4 months elapsed, my lord. So whether,
Yes.
my lord, between these 4 months, whether any witness is examined or not, that is the another aspect of the matter, my lord.
Take information. I have
Thirdly,
got
my
it.
lord, my lord, in this case, charge is framed on 9/8/2023, my lord. After framing of charge, my lord, the trial starts, my lord.
Yes.
So, my lord, during, my lord, yes, definitely, my lord, he is behind the bar, my lord, for
70 days.
670 days, my lord.
Charge was framed on when?
Charge was framed on 9/8/2023, my lord. And lordship has
Nine
already
what?
perused
9/8.
9/8, my lord.
23.
23. And lordship has already perused the order sheet, my lord. Witnesses stand up, my lord. But trial court, my lord, could not examine the witness, my lord, due to some other, there may be some circumstances or there may be some reason for which reason, my lord, trial court could not examine the witness. It is not that, my lord, witnesses have not come, my lord, and someone could not be served, my lord. So my humble submission, my lord, the contraband recovered, my lord, around 2,000 bottles of.
So you're going to submit, then we'll record, or if you want this status report, then it's okay.
No, my lord, my humble submission, status report may be called for.
Yes.
Otherwise, he has submitted, I have
Yes,
recorded
but
this
that
one.
may be taken into
But the
consideration.
question is, if you want to status report, then we'll fix a
Yes.
date. Or otherwise, if you want to
My
submit in this regard,
Lordship,
then we'll-
lordship may call for after the status report, my lord. And my lordship may fix a date, my lord, after vacation, my lord.
he is, as per him, he is already behind the bars since last 670 days.
670 days.
And then now, see, question is that as he has submitted, I have recorded only on 1, 2, 3 occasions, most probably the witnesses were turned up, in fact.
Yes.
But those were not examined, but
Not
that is not that cannot be the fault of the accused.
My lord. Even, my lord, it
Maybe,
is also
maybe
not-
it's due
not-
to some inadvertent, court may be otherwise busy because I know one NDPS case for to examine one PW in an NDPS case. For one PW, it may take the whole day, in fact.
My lord.
That is the question. So there may be other court may busy in otherwise. Time may not permit also. But whatever may be the reason, in 3 occasions as he submitted. In 3 occasions, the witnesses were present, but those could not be examined.
Also, reflected in the order sheet, in fact, my lord.
That is
Yes,
one of the aspects.
I have all the orders.
That is one of the aspect. So now, if it within the 4 months, if there is any progress that I cannot say.
My lord, that
Yes,
is all.
let him,
So,
let
let
it
the, my lord,
confirm and
Status report may be called for up to date. It has to be called for through registry, my lord.
Submitted by Mr. Purva that as per the scan copy of the LCR, the last witness was examined on 2/8/2024, and after the lapse of 4 months, if any witnesses are being examined by the court, it is not in the LCR, and accordingly he submitted that the present status report may be called for, along with the evidence of the PWs recorded, if any. Registry will do the needful, because he is in custody since around almost 2 years.
2 years.
My lord.
Almost, then can it be fixed on immediately after view vacation? 20, 20, 20 or 21?
Yes.
21 we are fixing?
21/1.
21/1.
More than a month. Anyway, I leave it. to you.
Otherwise,
Otherwise, I could stay 670 days, no program, another 1 month.
just a second, prior view kiba dibo paribo ni? Actually, what had happened prior view?
I know, your lordship. has
Only
fixed-
1 week is there.
Yes, yes. yes.
From 6 to 10, then
I-
again holiday.
I
That
know,
is
but
the
definitely, I know
that
your
is the
program also,
question.
so many cases, madam.
If it can be, and we trying to adjust, but
Yes, yes.
because he is in custody for a constitutional.
Possible on 18th is possible, 18th.
No, holiday. These are all holiday. That's why.
No, not this month, January.
January is holiday.
18th holiday.
Saturday.
From 10th is the last working day, from 11 to 19th.
Then
is the
21,
holiday.
right.
20?
Yes, 20.
Okay. Fix it 20. We'll dispose of the matter even if the status report comes, or even if, or you can file the status report
I
from the
I
website
try to
also
bring-
before
I'm
us.
Earlier, I can.
Because it can be.
Yes,
doing
I'll
that,
bring my, I'll
but
talk to
only
my.
to examine if
Okay,
any
I'll talk
witnesses
to
are
my-
being examined or
I'll
not.
do my, I'll talk to my lawyer.
Because there may be, the court may otherwise busy also, but the question is that in 3 occasions, 2 PWs were coming
Same,
and
same witnesses.
same witnesses were coming and they were
Send back without.
sent back
exam.
without being examined. That is the one of the aspect. We'll see to it.
It will remain as a part amendment.
Part হাটো নহব আৰু।
Otherwise, my lord, your lordship has given.
It may be listed here only, I think.
Passionate hearing, my lord, that is the matter.
It may be listed here only.
Obliged.
Expecting, I don't know, but maybe.
Very difficult to say, but.
For giving actually.
I think. Yes. No, it is, I think 8. I think 8 is.
May I please, Your Lord?
Yes.
Lordship, in this matter, I am praying for an adjournment, Lordship. Conducting counsel, Mr. A. Sharma is out of station, Lordship.
My lord is proposing a date, my lord, 17. 16, my lord.
No, not possible. In 1920 are the motion day, and up to 16 we are full. We cannot be, it cannot be accommodated on 16. Otherwise it could have been. But
Tomorrow, my lord. Tomorrow it will be difficult, Lordship. Today he has left, Lordship. Tomorrow he
now see, prior vacation, you can talk to her also. We have already given, many cases have been fixed. In fact, that apart, some other cases will come. That's why if today, if it was possible, then definitely I'm ready to hear. But from his side, most of it some. So obviously it will be after vacation only. We don't have any alternative.
Okay.
After vacation.
Date, my lord, may I pray for a date? Not because this matter is a old pending cases, my lord.
Yes, obviously old pending. Dates off. It's an old pending matter. আপোনাৰ prior বিহু মঙ্গলবাৰ বৃহস্পতিবাৰ if any date is there. Otherwise, if not, no need, because there are after bihu only. She's saying it will come only after bihu only. Any Tuesday, Thursday. Tuesday, Thursday will be
Any day.
because
30 January.
30.
My lord.
Okay.
Hello.
At the request made by the learned council for the petitioner side. And now with the consent of the litigant, petitioner side of 30.
Item 9.
Similar prayer for item 9, your lordship. Item 9, my lord, this is a conducted council with the SK Jain is out of station, my
11.
lord. Started, my lord, more than 11 years. If my lordship permits me, I can do my part, my lord.
For 11 years, what do you say?
This was, my lord, in the court below, my lord, it started way back in the year, my lord. Cause of action is of 2013, my lord.
Oh.
11 years, my lord. So if my lordship permits me, I can do my part, my lord. Their part, they can do it on Monday or Tuesday, any day, my lord.
See, that is the problem with us. In fact, prior bihu, we don't have any date.
Yes, my lordship.
And the part heard, sometimes a difficult part heard because we
We
are
are
on.
very small, my lord. Only one witness is there. Only one. Only one
No,
witness.
no, I can understand,
CJM
but
court and sessions court, they are in my favor, my lord. And my lord, very limited scope for argument also, because
Yes.
they have come up for revision. Only
What is
question
the
of
problem
law.
of your senior and this council?
Personal urgency, your lordship. That's why he's out of station. Both the cases, my lord, I have prepared, my lord, for final argument.
Same day, definitely. Same day. Up to 18, 19 matters only. All are old matters.
Started in 2013.
That is.
Now 24 is over, my lordship.
Election petitions are of 20. Election petitions to Huniboy. These were fixed on 28. on 21. After. No, she will be better in a position to see you. 21, 23, almost 14, 15 numbers of matters of hearing matters have already been fixed.
21, my lord, I have a little problem. I have a debt reference also for the division bench.
Okay.
It's fixed.
21.
Yes, my lord. That T of the state matter case.
23 also
Product
same,
not-
23 also same.
This won't take much time otherwise. This case is.
But
my lord,
it has to reach
yes,
that
but
deadline.
my lord, both the parties, my participation is necessary.
Yes. Will be
I'm
there.
praying only, I'm praying for a date only, my lord. That is, my lord, that would. be
That's what we are
sufficient.
searching
Yes.
for you. Date is এটা পারিব মোবাইলে তো নাই আর উপায় তো নাই
30.
Your earlier matter was fixed on is fixed on 30th 30.
My lord.
Can it be on the same day 30?
Yes, my lord. Yes, my lord, Thursday.
You're waiting since 2013
Yes,
so
my
another
lord.
1 month.
Yes, yes.
30.
30, my lord.
Oh. But now his EIFs have submitted that he was ready to argue the
Argue
part
the-
30s of yes from his side. So please convey your thing to
Yes,
your
sir.
Kankis council so that matter doesn't remain unheard.
Yes, sir. Yes, sir. Deeply obliged.
30 back is same prayer on the request. Again, here also you are for the petitioner.
Yes, your lordship.
Is there any interim and all? No.
No, your lordship.
Oh, it's a case.
Final
Okay.
hearing,
Final
sir, NIX matter.
enactment.
Yes, my lord. Deeply obliged.
Much obliged.
May it please your lordship.
Yes.
My lord, in one case, lordships, I am for the petitioner, and in other case,
In
am
10, you are for the petitioner or?
10 lordships, that is 439, criminal petition, I am the respondent
You are
lordship.
for the respondent and other one you are for the petitioner.
542,
Huh.
I am the petitioner lordship.
Yes, yes.
Lordships, may I pray for
Hmm.
some accommodation after the Bihu lordships? Because today I had the talks with my client lordships. He is out of station. And both this Ganesh Majumdar and Srikanta Pathak, they are the friends. Some talks I heard, it is going on between them lordships. And he is out of station. And this is a case of NI Act lordships. So my prayer before this honorable court, matter may please be taken up after Bihu lordships. In the meantime, there may be some settlement also lordships.
What is due?
No,
So
the lordship, I don't have any instruction regarding that there is a talks going on between the parties. There's no instruction. My instruction is that I should go for the hearing. And there is no talks between them as submitted by him. Maybe his client has submitted like that, but in my case, there is no talks between them.
You don't have any such instruction.
And regarding the fixing the matter after the Bihu vacation, but it's very difficult to list the cases, lordship. So I'd like to go for the hearing to the lordship.
Lordships, a date may please be fixed after the immediately after the vacation lordships.
But
Immediately
Now
after
you
the
decide
vacation.
yourself. We are here to ready.
But under what ground? Under what ground? He is here, I am here. I'm saying there is no talks going on. Why cannot there be a hearing on today?
Do you have any instructions, such kind of instructions?
Lordship, today.
They may be friend for that. That's why for the friendship only, there maybe there mandatory transactions were there or whatever. But the question is, do you have any instruction in that kind?
Lordship, today I had the talks lordships. He is out of station, out of Guwahati lordships.
His presence is not required here, lordship, for hearing.
No, not at all. No, he is not on that. He is saying that he is out of station. So out of station, then what happened?
Out of station, and as both the petitioners and respondents, they
Are
the
friends.
Friends, lordship.
Yes,
They are
that
the
I
friends,
understood.
lordship. So some talks are going on because this is the case of NI Act. My client lordship seems to be issued two checks, Lordship, 5 lakhs plus 5 lakhs. And that is against that, Lordship, there was order was there by the learned trial court, altogether 18 lakhs plus 18 months.
It's okay. There are the checks are there.
Lordship.
That's why it is the case of the NIA. So you were convicted.
Lordship, convicted.
Okay.
Lordship.
Lordship, it's a 2008 case, Lordship, the trial court. And friendship is lost long back. There is no communication between them. I'm sure about that. Long back friendship was lost because due to this issue, Lordship. 2008 trial court case, Lordship.
You tell us to decide yourself. I'm just what to say.
No, I'm not onto that, Lordship. It is very difficult to list the case, Lordship, these days. Very difficult. I have been with the registry. I'm going to registry time and time again. Very difficult, Lordship. I don't agree to that, Lordship. We do apology to him. He's quite senior to me, but if he can assure me that it will be listed in the first week of January, if he can assure me, I know to that. I can do that. That much accommodation I can do, but not after Bihu and all, because it's very difficult, Lordship. I'm finding because I understand the bench, Lordship, because it's very difficult from the bench. Registry is overburdened in listing the cases, Lordship.
Lordship, first week of January, Lordship. A date may please be fixed, Lordship.
That is the main issue.
And,
We don't have
Lordship, and Lordship, my prayer would be whenever the date is fixed, it is on the top of the list, Lordship. It has
I
to
also
be fixed
agree
like
on that, Lordship.
top of the list, Lordship.
I agree on
If that it can be fixed like that.
first week of January, top of the list.
We don't have any dates. Main issue is that only. First week of January is only up to 6 to 10th, and we don't have any dates.
And
Third
Lordship,
is the working day, and fourth, fifth, again, fourth, fifth, again, holiday. So from 6 to 10th, prior to Bihu, in fact.
in that case, Lordship, my prayer would be to go for the hearing today, Lordship.
Top of the list of question I have. Top of the hearing this, can it be there?
Of the days that you can be listed on. First, immediately after.
Top of the list.
After. So the 21st and
She is
Lordship.
saying that if you want, it is on top of the list, then maybe on 21st of January. Otherwise, there prior to that, we don't have any. In fact, in the last 2 dates also, I have given 30th of January because we don't have any dates. In 21 and 23rd are full, in fact. So though it is listed, I cannot say it exactly. There are motion matters and all. However, if it is can be listed in the top of the list, maybe one attempt may be there in 21st of January. 21st is a hearing day, I think.
21st,
Tuesday.
21st, Lordship, actually I have a Kohima bench, one Kohima bench, right?
Oh.
It's a fixed.
Tuesday, Lordship.
23rd
Can be.
can be.
10 and 11, and the request made by Mr. R. Sharma, the counsel for the respondents, that's petition. The matter be fixed on 23rd of January 2025 at the top of the hearing list. It will do. But as he has submitted that it is such, I can understand listing is now it is very difficult because of overburdening of the bench as well as registry. Well, so if it is listed on the top of the list, go for the hearing. And I also go by the Mr. Dekar that probably to compromise at this stage may not be there. I think if it is there, I cannot say, but
There is no possibility. Lordship.
may not be possible. But even if there is any possibility, then try and just let us know before the court, you just place it. Or rather, you can bring the clients also if there is any talk of compromise, let the Mr. Tekabi know to, if there is any such development. Obviously, in that case, suppose interest can be waived and all, that may be one of the option also, suppose. If the other subject to that, if the other party agrees.
I would have informed actually, yeah, had there been any such talk?
Yes, definitely.
I don't inform.
But he had no such instructions. That is the issue. So try on 23rd. Let us see what happens. Okay, we'll try.
Item 12.
May it please the loss.
Yes.
My lord, admittedly, it's a lost case of the petitioner, my lord. He lost in both the courts below. It
Okay.
is, my lord, in the complainant who gave him 6,60,000 rupees, filed a case before the civil judge, before the CJM at Silchar, my lord. The case under NI Act 138, which was tried, and it was went against the petitioner, my present petitioner, and there was an order that he has to pay the 6 lakh rupees. and
Order was
if
for
he
6
failed-
lakhs. Order was for 6 lakhs.
Yeah, order was for 6 lakhs, and he has to return 6 lakhs. If he fails, then 6 lakhs with lump sum interest, and if he fails, 6 months are right. Again, this is file appeal before the CJM court, my lord, and the CJM also dismissed the appeal. The only
CJM?
point I have seen here, my lord.
Sessions license, my lord.
Yes. The only point the small point here, as noticed by myself, my lord, he exhibited exhibit C, the complaint and respond opposite party accused person in the CJM code exhibit C, and telling that he returned the money and the exhibit C was executed by the complainant as received. But the complainant refused. No, I did not exhibit any receipt. He did not pay me this thing. Then
Exhibit C was exhibited by the petitioner
it is
or the accused.
accused, my lord. Then it was sent to the forensic.
It was a receipt, money receipt.
Receipt, my lord. In the forensic, the receipt was examined and the result came in his favor. That yes, it is the handwriting of the complainant. But facts amended, but that handwriting expert report was not examined before the court. He failed to adduce evidence. No, it was not, the handwriting expert was not examined before the CJM.
Why
Over
don't
and
you
above-
pray for examination or to recall the, to call for the?
Yes, my lord. Then
You have
he
not.
filed- He did not.
No, no, he did not is separate thing. You have not prayed for calling this FSL expert as an witness?
No, he did not call it. It's a fault found by the trial court itself. Then
Why
it-
don't you pray for?
My lord,
Why didn't you pray for recording on the witness of the FSL expert?
it was sent, as per his prayer, it was sent to the handwriting expert. A report came in his favor. Then during trial, it was his duty to bring the handwriting expert and to examine.
Suppose it is
He
duty
did
to
not
bring the FSL
Yes,
expert
ma'am.
by the court.
Yes, ma'am.
But you could have made a prayer before the learned trial
He
court
did
below.
not, his counsel failed to do it.
That is your part.
And then he filed appeal also, my lord. Then the appeal was also declared, my lord.
So now it is, now the question is that though the money receipt, wherein your signature of the complainant was examined and it came positive.
It was
Suppose.
positive.
In that case also now it is in the eye of law what to do if you had not examined the.
He
the
failed to examine. Admittedly, he failed to examine. Then he filed appeal. In the appeal also, it was not considered. Now the small question, if you lost it, please, my lord, then if the handwriting expert is, he may be given an opportunity to examine the handwriting expert, if possible. I just leave it for the lawsuit, my lord, for consideration. Otherwise, there is no merit in the case. He lost in both the case. For the sake of argument, I don't like to argue the case, my lord, because admittedly there is no point except this small one. And during the only thing, that thing I think that during the pendency of this revision before this formal court, the complainant died and he was a confirmed bachelor. So his brothers and sisters are implicated, and my learned friend is representing them. So I leave it before lawsuits, my lord, if law permits. Otherwise, so far, truly speaking, my lord, I don't feel it's a good case for the petition. Only the small point is this one.
No, well, the report is available in the case record?
The report, maybe.
Report.
The report will be.
Expert report is available in the case record.
Yes, sir, in the case record. The records are called for it, maybe we will do the call for it.
It has already been exhibited at Exhibit C.
Exhibit C.
Exhibit C.
C, madam. Exhibit A, B, C. By A, he paid small amount of 50,000. By B also he paid small amount of 50,000. These are admitted by the complainant, yes. But as for the exhibit C, by which he is telling that he paid money and the complainant executed the receipt to him, the complainant is denied. Then it was referred to handwriting expert. And fortunately or unfortunately, it came in his favor. But there is a lacuna committed by the learned counsel.
For it was prayer from your side to
Yes,
send it for FSL,
from the petitioners.
to send it for FSL.
Yes. But later on, the advocate defaulted to examine this in that manner. Only this is a small point, my lord. Otherwise, there is no point, my lord. Others, the judgments are very detailed, both the judgments, and it is all along against him. At this stage, if you lost the pleadings, then it will be remanded for this part of the examination to be done by the trial court, allowing the petitioner to examine the handwriting part.
We have exhibited this one, but where is the report of the FSL is also available? Or not yet available, not available?
I don't know whether it is contained in the record or not. I know the initially records of four format.
FSL report was as per your information, whether FSL report is also available here? No.
FSL report.
Exhibit
C to be like FSL report. Oh, FSL report was not exhibited by us. Only the receipt C.
It is not exhibited.
FSL report was not exhibited because
FSL report is available here.
For the court.
No. FSL report is available here or not available?
It is not available. Okay, because now only the exhibit C, the receipt. Receipt was sent with the handwriting expert. The report from the handwriting expert was available.
No, just I am asking you whether FSL report is available in the case record.
That I cannot say, my lord, because it was sent from the judgment is away that it was sent and the report came in his favor.
Lordship permits me, I like to clear me on this point.
Page 24 may can live in, madam.
24 of?
Page 24 of the.
Your petition.
Petition, madam. It is continuation from page 23, madam. So in the top, it is written, Exhibit A and B. He has also stated that he has also received rupees 50,000, the complainant, from the accused pro demand draft. The defense has heavily relied on Exhibit C, which is the money receipt purported to have been executed by the complainant on 15/9/2010 after receipt of the rupees 6,60,000 from the accused. Again, the check number so and so dated 9/9/2010. It is also mentioned in Exhibit C that the check was misplaced in the custody of the complainant, then same would be returned back to the accused after recovery. However, the complainant did not admit this document as being executed by him, and also he denied Exhibit C1 signature as his signature. In this context, the signatures were examined by the handwriting expert at the direction of the court. After an application made by the defense for examination of the handwriting expert, a report has been sent by the forensic department, Kailapura, Guwahati, which reflects that the signature mentioned in Exhibit C and A and B are written by the same person who wrote the specimen signature, it is complainant. But the document report was not exhibited by the defense. Nevertheless, in the light of section 292 of the CRPC, as this report has been furnished at the direction of the court in the proceeding of this case, and it is admitted as evidence, even though the handwriting expert who has made the opinion was not examined. Consequently, court did not believe and dismissed his stand, and the case was granted in favor of the complainant. Again, the revision was appeal was filed before the Court of Chief Judicial Magistrate, and London Chief Judicial Magistrate dismissed the appeal. By leaving before the lawsuits, the two judgments may kindly be perused, and hearing my learned friend also my. Other than this, I have nothing to say at this point.
Mr. Lordship. Well, the instant revision petition filed under section 397 of the CRPC, my lord. And this is revision against the concurrent findings, my lord. My learned senior this point raised, my lord, against the concurrent findings, my lord. On this point, the revisional concurrent findings against the revisional court, my lord, score is very narrow, my lord. Already this honorable court as well as apex court, I have brought some citation, I will rely later, my lord. So on that ground, my lord, the plea raised by my learned senior is not at all maintainable, my lord. First of all, my lord, before taking to your lordship, the fact of the case, if I like to lordship some trouble, my lord, in this matter, my lord, some dates of exhibit is very much relevant in this matter to substantiate my claim, my lord. Here, my lord, I am representing the complainant. I exhibited in a trial court. My lord, first exhibit, my lord, exhibit 1 kindly note it, my lord, is the check in concern, my lord. Exhibit 2 is a return memo, my lord. My case will start from exhibit 3. It is legal notice, date may be not kindly noted, 21/10/2010, exhibit 3. That means 21 October 2010. Now, lordship, exhibit 4 is a edit card, and exhibit 5 is the poster. I am not on there. Now, my lord, my contention next is exhibit 6 and 7. Exhibit 6 is the reply to my legal notice. The petitioner's replied on 30/10/2010. That means 13th October 2010. Kindly mark it, my lord.
10 when?
And
Exhibit 6.
Exhibit 6 30/10/2010. 10, my lord, in the year of 2010, my lord, the instant complaint and I 138 proceeding complaint petition I filed, my lord. On, my lord, 10/7/2013, during pendency of my complaint case before the trial court below, that is exhibit 7. Exhibit 7, the petitioner has made an application. He admitted, yes, that complainant is entitled 6,60,000 rupees. I will take your lordship. But kindly, my lord, exhibit 7, petition dated 10/7/13. 10/7/2013. And same date, my lord, trial court has passed order, same date, on 10/7/2013. I brought all these things, my lord. Now, my lord, petitioners relied 3 exhibits, my lord, in this case. Exhibit A, B, C. Now, my lord, exhibit A, money received, date kindly note, my lord. Exhibit A,
money received, that is 40,000 rupees received by the present complainant. That is a 4/11/2013, my lord. Next, my lord, Exhibit B, money received, 1,60,000 paid to the complainant. That is on 28/8/2013, 28 August 2013. That means, my lord, after Exhibit 7 petition made on 10 July 2013, thereafter Exhibit A and Exhibit B, this amount he has paid, my lord. Now my learned friend is disputing Exhibit C. What is Exhibit C? I will show your lordship. Exhibit C is a letter dated 15/9/2010. My lord, kindly mark it. My whole case is based on here.
Exhibit C is
C is the 15/9/2010, 15 September 2010. Now, logic chronologically, I will make my submission now. That means, my lord, as per his submission, on 15/9/2010, he paid me whole amount. As per his, that I received 6,60,000 as per contention of the petitioner. And I will not say against that now, petitioner. Then, my lord, 15/9/2010, he has said he paid all the amount. He exhibited his Exhibit C. Now, my lord, when he received my legal notice 21/10/2010, he replied very same month, 13 October 2010, he denied, I have not taken any amount from you. Kindly mark it, my lord. Exhibit 6 dated 30/10/2010. And Exhibit C is a 15/9/2010. It is a September, is a October. September Exhibit C, he has relied, said that he has already paid this amount to me. But in legal notice reply, he has said that no amount is due to him. Now, my lord, if that be so, then Exhibit 7, petition made before the trial court below 10/7/2007, my lord. And Suman, please. Absolutely, both the trial courts below discuss all these points. Here, lordship will see my exhibit first.
Exhibit 7.
Yes, my lord. Exhibit 7. Yes, this is the petition, my lord, by the present petitioner. Today is the date fixed of the case. The accused petitioner with given amount of rupees 6,60,000 rupees amount of month from today. And I will take all the liberty to hand over the said amount to the complainant, and with the aforesaid amount due as such an adjournment, he has sought adjournment that he will pay this amount. Accordingly, very same day, this one, next page, my lord. The order passed by the same court. The both sides are present. Since the petition number 3526 filed by the accused, praying for time to pay the amount prayer is allowed. That means after he himself admitted the 6,60,000 he is going to pay to me. When it is 2013 during pendency of the matter. Now, my lord, and Honorable Trial Court has recorded he is going to pay accordingly after 10/7/2013, my lord. The exhibit and exhibit this amount he has paid to me. And now he said the Exhibit C, the 15/9/2010, prior to receive legal notice, he paid all the, my lord, from the right from the beginning, the petitioner has tactfully, my lord, trying to confuse the courts and mislead the courts, my lord. He's enjoying delaying the matter in this matter. My lord, only 2 paragraphs I will read from the appellate courts, my lord. In all the places, he has taken the contradictory stance, my lord. In appellate court's lordship will find, my lord, page 37 is the order. I will take your lordship directly, paragraph 12 and 13. The last impugn order, my lord. Page 42, my lord. Elaborately discussed, my lord. Peruse Exhibit 6. That is, my lord, the reply notice. Peruse Exhibit 6 of the reply of the advocate notice reveals that the accused appellant's stand was that he never approached the complainant for money, nor did he receive 6,60,000, and the check is a false document, and the accused appellant never signed any check to take loan from the complainant to the tune of rupees so and so. On the other hand, during argument, during the trial, accused appellant side has submitted that the documents that is the exhibit C, whereby the accused appellant has paid rupees 6,60,000 to the respondent complainant, that is on 15th September 2010, against the check number so and so dated 9910, and it was mentioned in the exhibit C that the said check is misplaced in the custody of the complainant, and the same will be returned back to the accused after recovery. The stand is completely contradictory with the stand taken by the accused by the exhibit 6. The record reveals that during statement of the accused under section 313 of the CRPC, the accused has stated that he would adduce his own evidence and other witnesses, including the handwriting expert. The record also reveals that the several dates were given to the DW, but the accused side had failed to adduce any evidence, not to speak of calling the expert to prove the opinion. The contents of Exhibit C does not inspire the confidence of this court because of the fact that the same was illicitly exhibited on 15 September 2010, that is prior to filing of the NI case 7810, and the accused is paid rupees 40,000 on 4/11/2013, that is Exhibit A, 1,60,000 on 28/8/2013, Exhibit B, and 50,000 through the demand draft, that is 8/10/2013. If the whole amount was paid through Exhibit C, then there was no question of making payment of aforesaid amount by Exhibit A and Exhibit B as well as demand draft. Well, kindly mark it. That apart, that Exhibit 7 shows that during pendency of the case, the accused appellant had filed petition number so and so dated 10/7/13, that is Exhibit 7, wherein Exhibit 7(1) is the signature of the accused, by which the accused prayed for an adjournment and further state that he will pay the rupees 6 lakhs within 1 month. In view of the above position, more particular execution of the Exhibit 7, Exhibit A, and Exhibit B, and also demand draft of so and so in favor of the complainant, the content of the Exhibit C is not believable in this court. Upon consideration of the oral as well as documentary evidence on record, and also upon consideration of the decisions of the cases referred by the respondent side, it is found that the accused had issued the check in favor of the complainant, and the same was deposited in the bank and returned dishonored due to the insufficiency of fund. And as such, the presumption under 139 NI Act will come into play, and it has the burden of the accused to rebut that he had not issued the check against any debt or liability. In the instant case, the accused side failed to rebut the same. On the other hand, upon consideration of the available evidence on record and also upon the consideration of the decisions referred by the respondent side, I am of the opinion that the opinion of the FSL expert is available in the case record by itself cannot be considered as an evidence unless the same is proved as per law and also supported by the corroborated by the other evidence. The accused side, in spite of giving opportunity, has failed to call the expert to prove the report and thereby deprived the complainant side to cross-examine such expert upon contents and also as on which what basis the said opinion was given. As on the face of the opinion, no reason was shown. The oral and documentary evidence has not corroborated the FSL report, rather the same contradicts the contents of the Exhibit C. After going through the impugned judgment, I have found that the learned trial court has considered all above aspects such as oral as well as documentary evidence has rightly come to the conclusion that the accused has committed offense under Section 138 NI Act and accordingly convicted him. The case record further reveals that the learned trial court, while passing the sentence, has considered the part payment of rupees 2.5 lakhs made by the accused and accordingly sentenced to sum of rupees 6 lakhs, including lump sum interest as fine, that is RI for 6 months. And it was ordered that the fine amount, if realized, is to be paid to the complainants as compensation. After going through the impugned judgment, I do not find any illegality or irregularity committed by the learned trial court. As such, there is no requirement for interference of said. That means, my lord, in paragraph 12, 13, all these things, learned appellate court is recorded, appreciated, and trial court's evidence. So all these things discussed by the concurrence finding by both the court, my lord. Even, my lord, his lapses on that part, since FSL, the witness, my lord, he's supposed to call, my lord. Admittedly, both the court below had recorded, he failed to call this evidence. Since had it been supported him, he would have been called that evidence. But same has not been done, my lord. I am not there, my lord. I am on this, my lord. Since he received my notice on 30/10/2010, he denied no payment is due to me. If that be so, then Exhibit C, the prior September, he said, I have received all this amount. It is a contradictory. Second, my lord, Exhibit 7, in front of court, he made an application. He admitted for adjournment. Yes, I'm going to pay. After adjournment, after the order, he paid Exhibit A, Exhibit B to me. Then, my lord, in such NI case, my lord, the main vital issue involved here, since my lord, he didn't rebutted the evidence laid by the complainant. So you don't have case, my lord. First of all, on the maintainability is concerned, my lord, I humbly submit, my lord, if a lordship permits me, I have brought some citations, my lordship may produce data, my lord, wherein Honorable Apex Court as well as our court, my lord, had discussed elaborately that against concurring finding scope of this revisional court is very narrow, my lord. My lord, senior has requested, lordship may give direction for fresh FSL. Absolutely, my lord, this is a very, what shall I say, my lord, this is not at all permissible or maintainable such kind of plea in this case, my lord. And Diana, please. 2023, 10. 2023, 10. Out of the year. Air Online 2019. Yes. No, that's what an answer to one. Yeah, 2023, 10. Out of the year. Ready. 2019. 1326. 1326. 1326. Not. How to that year? 2012 9 to year. 12 9. 2012 9. Out of the year. 2019 99. Sorry. My lord, first citation, I like to like this, then I will take a lot of books. 2012 9 to dear. Here, my lord.
First relying on which one?
My lord, first on maintainability ground, I will, my lord.
No, which
2012 9 SSC 460 Amit Kumar versus Ramesh Chandra.
2012.
Yes, 9 SSC 460, my lord. Party's name is, my lord, Amit
Yes.
Kumar.
Yes.
Here, two paragraphs, my lord, 12 and 13. Regarding revision maintainability, my lord. Section 397 of the code vests the court with the power to call for and examine the records of the inferior court for the purposes of satisfying itself as to the legality and regularity of the proceedings or order made in the case. The object of this provision is to set right a patent defect or an error of jurisdiction or law. There has to be well-founded error, and it has not be appreciated for the court to scrutinize the orders, which upon the face of it bears a token of careful consideration and appear to be like accordance with law. If one looks into the various judgments of this court, it emerges that the revisional jurisdiction can be invoked where the decisions under challenge are grossly erroneous. There is no compliance with the provisions of law. The finding recorded as based on no evidence, material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely, my lord. These are not excessive clauses, but are merely inactive. Each case would have to be determined on its merit. My lord, only paragraph 12, that is, my lord. Second, my lord, 1999 2 SEC 452, State of Kerala versus Puttumada. 1999, my lord, 2 SEC 452. State of Kerala versus Puttunama versus Illat.
Yes.
Yes. Here only one paragraph, paragraph 5, my lord. Having examined the interim judgment of the High Court, may I read, my lord? Having examined the interim judgment of the High Court and bearing in mind the contentions raised by the learned counsel for the parties, we have no hesitation to come to the conclusion that in the case in hand, the High Court has exceeded its revisional jurisdiction. In this revisional jurisdiction, the High Court can call for the examine records of any proceedings for the purpose of satisfying itself as to the correctness, legality, or propriety of any finding, sentence, or order. In other words, the jurisdiction is one of the supervisory jurisdiction exercised by the High Court for correcting miscarriage of justice. But such revisional power cannot be equated with the power of an appellate court, nor can it be treated even as a second appellate jurisdiction. Ordinarily, therefore, it would not be appropriate for the High Court to reappreciate the evidence and to come to its own conclusion on the same when the evidence has already been appreciated by the magistrate as well as session judge in appeal unless any glaring feature is brought to the notice of the High Court which would otherwise tantamount to gross miscarriage of justice. That must be not. Next, my lord, another citation of our court, my lord. That is 2006 4 GLT 303. Paragraph 18. These are all discussed regarding maintainability on revision against concurrent findings, my lord.
Para?
Para 18, 1-8, my lord. Small paragraph, my lord.
Yes.
This criminal division petition has not been preferred under section 401, but preferred under section 397 CRPC, where the power of the High Court is limited in the particular area. The High Court in exercise of its jurisdiction under 397 CRPC cannot exercise its divisional power as a second appellate court, second appellate power. Therefore, this court in exercise of its jurisdiction under section 397 CRPC cannot entertain and adjudicate the fresh controversy in the name of question of law. Raising fresh disputed facts and evidence before this court by way of criminal revision cannot be attributable to a question of law. As such, the disputed fact that the 5 checks were not presented directly or indirectly to Ecobank or only 1 check was submitted cannot be a point for adjudication before this court. More so, this cannot be a real cause to test and penal action under section 138 of the NI Act in view of the settled position of law that the complainant can present the dishonored check as many times during the validity of this period. My lord, already this honorable court also held that the limitation of the divisional court. Now, my lord, the rest two citations I like to rely on this point. Since, my lord, the defense failed to rebut the evidence raised by the plea laid by the complainant. Under such circumstances, what is the view of the apex court, my lord? First citation I like to rely, my lord, 2023 10 SEC 148, please. That is Rajesh Jain versus Ajay Singh, my lord. Para 55, then 61 to 63. Para 55, my lord.
Yes.
Yes. At a stage when the courts concluded that a signature had been admitted, the court ought to have inquired into either of the two questions, depending on the method in which the accused has shown to rebut the presumption. Has the accused led any defense evidence to prove and conclusively establish that there existed no debt or liability at the time of issuance of check? In the absence of rebuttal evidence being led, the inquiry would entail, has the accused proved the non-existence of debt liability by preponderance of probability by referring to the particular circumstances of the case? Here, my lord, he has to, his only defense, my lord, he has to rebut the evidence raised by the complainant. Now, my lord, paragraph 61, small paragraph 61, 62, 63. Finally, my lord, what observation made? The fundamental error in the approach lies in the fact that the High Court has questioned the want of evidence on the part of the complainant in order to support his allegations of having extended loan to the accused, when it ought to have instead concerned itself with the case set up by the accused and whether he had discharged his evidential burden by proving that there existed no debt liability at the time of issuance of check. In the teeth of the aforesaid analysis, we have not the slightest hesitation to concluding that this case called for interference. In spite, notwithstanding, both the courts below have concurrently held in favor of accused. Since we have answered point number 1 in a negative, the need to be examined point number 2 does not arise. Hence, we proceeded to allow the appeal by setting aside the judgment of the High Court of Punjab, Haryana at Chandigarh, rendered in Rajesh Sencho, dated Sencho, allow the complainant to file under section 130 Negotiable Instrument Act and convict the respondent accused with a fine of twice of amount when check rupees Sencho. This is. And finally, my last citation, my lord. It is Air Online 2019 Supreme Court 1326. And among them, one of my court below, this is Honorable Justice Rishikesh Roy also there. There is only paragraph 7 I will read, my lord. Yes. Admittedly, the parties has entered into an agreement of sale dated so-and-so. It is also an admitted fact that the respondent complainant had paid of rupees so and so as an advance earnest money to the appellant accused as per the terms of the agreement. As pointed out by the High Court, the appellant accused has not disputed his signature on the check presented for clearance. Contention of the appellant that the check issued in the name of the firm named Swencho Solution Incorporation was removed from his office table to be inconveniencing, not the same supported by any evidence. As pointed by the High Court, in the statutory presumption under Section 139 NI Act, the appellant accused has not satisfactorily rebutted the statutory presumption. In view of the above, we do not find any ground warranting interference the conviction of the appellant accused under Section 139 Act. Here, my lord, I am concluding my submission, my lord. First of all, both the courts below, awarded 6 lakhs of rupees and in default 6 months of RI rigorous imprisonment to him, my lord. Then he preferred the appellate court appreciated all the evidence, discussed all the evidence thoroughly, and what the lapses on his part is also discussed by the appellate court, my lord. And against it, both the courts below, the instant revision petition filed in the year of 2020 and 2020, the petitioner obtained on interim state, my lord. Now this 2024 and my lord, and by that time the main complainant he died, my lord. Subsequently, we made a subsequent application according to this allowed us to legally represent. Now, my lord, I'm very surprised that at this also, despite all the exhibits see all this contradictory said, despite all this being, he has requested this honorable court, therefore, fresh evidence, lordship, interfere both the courts below finding interfere. My humble son, otherwise, my learned senior, I respect him a lot. Otherwise, if other consuls appear, I could have made clear that some imposed cost is to be imposed on, but I'm not praying though. So, my lord, my humble summary in this case, such kind of revision petition, such kinds of interest, such kind my lord, I am also, my lord, since this matter is pending, my lord, the trial court passed order, my lord. Trial court passed order on 2018, now 2024. So we are entitled some interest here in this case. So my learned senior also is very good enough, my lord. He is suggesting me. So this revision will be dismissed and my lord, with interest, whatever we amount, same will be granted. Oblige me not.
Otherwise, Mr. Raj Boyavi has fairly submitted.
Yes, absolutely. I do admit. Therefore, my lord, that part I have not argued. My lord. Is it very fair? Is it very fairly argued, my lord?
The legal layers or the interested party has already been.
Yes, my lord. Lordship, I have brought their order. Lordship, kindly. More order to Anisu. My lord, I am giving this order.
He died during the pendency of this court here in pendency.
Yes, man. Yeah, that's good. I'm giving you. It is order. My lord, Justice Adishadori has passed in IM lot 299-2023. IM lot criminal 299-2023.
Order dated.
I'm giving you that order. Silly, I think good. My lord, this is the order.
You supplying this one to?
Yes, yes, lordship for lordship.
Order is approved. Order is reserved.
Deep love.
Mr. Blind.
How to know? Koi do, koi do. I think time won't permit. I think I'm not in a position to hear the matter now.
The appeal for against acquittal.
Yes.
Are you appearing for the respondent number 1?
You are appearing for the respondent number 1. Oh, who is the? Oh, state is the appellant. Can it be fixed on other day because it will be
As
again
per your
being
lordship
part, right?
convenience, yes.
And what nature of case this one?
Lordship, actually, my learned friend, Mr. R. Borua has gone through the case, Lordship. So,
No. What, under which section he was, I mean, case was registered or he acquitted?
378 of the CRPC, Lordship.
Three?
Appealing 378 of the CRPC. Lordship.
No, it is okay. Section
what?
was section registered here.
Yes, Lordship, under section PCA.
On the
Lordship,
PCA.
PCA.
Yes. Your petitioner got
Under
acquitted.
section 7 and 719 13
Yes.
IND.
Okay. So respondent otherwise got acquitted.
Yes.
Positive reading.
Time 11.
Why don't they-
It's already about to be 4. I have a hard hold the day.
Yes, Lordship.
Yes. Lordship, kindly give it that after vacation.
Actually, date is very problematic for me.
Yes.
Will you
month
do
of January.
help you after vacation? If it is after vacation, I will not going to give any date in fact. If it is after vacation,
The month.
after vacation,
Yes,
the
registry
registry will
fix the date,
fix the
Lordship.
date.
Yes, Lordship.
It is a case of 2022,
Yes.
in fact.
The date of judgment is 25/11/2019.
2019.
Yes, Lordship.
After vacation, so we don't-
Yes.
it will be listed after vacation. The date is not possible now. At present.
Alright.
16.
NCB, Lordship, 16.
16 is NCD.
May it please your lordship, my lord.
16, I have seen that the person is behind the bar since more than 6 years.
My lord, already 7 years, 10 months, 14 days.
What was the conviction term?
10 years, lordship. So lordship, my bail petition may be considered, lordship. Because
It
otherwise,
will be
lordship, this is
here,
a
finally it will be heard. Shall cannot be considered.
lordship, this case, otherwise this case is completely because for non-violation of the section 52A of the NDPS Act, lordship. This is a clear case of acquittal.
Then actually,
8
when I
years
filed the cause list, I was about to hear the matter. In fact, I was thinking
Yes,
of hearing this matter at the earlier, but the other matters were going on, so it was left out. Otherwise, I have seen that more than 6 years, that now you are saying that is
Yes,
almost 7
8
years.
years, lordship.
Almost 8 years.
Almost 8 years, well, 2 years only left, lordship. So
Yes. Where is your senior counsel?
Left the court, Lordship.
Huh?
Left the court, Lordship, due to some urgency, Lordship.
Only left the court.
Lordship, they can complete their part, Lordship.
No, part heard will not. Part heard is not possible.
Will submit written argument, Lordship.
Submit to written argument, but part heard, because roster we cannot say at this
Yes,
stage.
lordship.
It may
So-
change, and thereafter also due to some my personal reasons, most probably I may be on leave also. So part heard will again affect you, the other side only, mainly. Not you, but the other side.
My lord, my IA is also pending, lordship.
I will be disposed of accordingly. Now is not met. তেখেতৰ এই মানুহজন প্ৰায় around 8 years সোমাই আছে. So give a date wherein can be listed as a on 9th. we are living upon all these cases and we are giving you 9th, though we are not listing in this week. However, as because of his detention, we are listing it on 9th. Just remind us in the morning hours. 9th is a
Hearing.
Thursday. It's a Thursday
Yes.
hearing day, so it will come. And probably your senior also is asked to asked him to present here. Or if you want to file any written argument, file on that day itself. No further adjournment because the person is, they now see he is almost 8 years, that the conviction is 10 years. It's very urgent. Here we're going to hear this one. Acquittal or convicted, that is different aspect, but matter should be heard in fact. That is. So we are listing it on 9th, though we don't have time, but we are listing it on 9th. Just remind us.
Yes.
Just he is behind the bar, so it's
Morning, Lord.
morning was 9/1, 9/1/25.
Obliged.
Oh.
17. Obliged, Lordship.
Parties are requested to proceed with the hearing the heat of knowledge, no further adjournment. And without further adjournment, we'll hear.
Lordship, kindly the matter may be listed after vacation, Lordship.
On 4th of February, my lord, item 17.
Please do 4th of February. One minute for you also. You are for the petitioner?
Petitioner.
Appellant, my lord.
Appellant.
Oh, sorry,
Against
appellant,
acquittal.
appellant.
Appeal against acquittal,
Appeal against acquittal.
my lord. Very limited power.
What case was under which section?
NI.
Oh, it's NI.
NI.
Nampitan rule. 4th of February, we're listing it.
My lord. Be clear.
Thank you.
19.
Lord, here I am for respondent lordship.
Mr. Name of one, the council is Mr. J. Lashkar.
Yes, lordship. Lordship,
It is a criminal revision petition.
criminal division lordship.
Are they enjoying any interim and all? No.
Yes, lordship, they are enjoying in lordship. That's why without paying any lordship.
It's a matrimonial matter.
No, lordship. That this
NI.
is a NI Act.
Oh, NI.
Yes, lordship. 6 lakhs was lordship granted, but they have tried before this honorable court lordship that since the accused is an old aged person lordship. So this court lordship only on the condition that on the next date case will be disposed of. So only on that condition lordship that
Interim was there.
judgment was suspended lordship for only till next date. But since then lordship almost
It is
1 year
extended.
passed. Yes. Sir. So, lordship, I may be deprived lordship if lordship something happened lordship in the meantime. Lordship. Because admittedly he is an old person lordship. This is an NI Act case lordship. Concurrent findings lordship.
He is 88 years. 8 years.
Almost.
Almost 8 years.
lordship. Otherwise I will be.
Pray for him then.
Because no relief subsequently.
Yes. In other occasion also, he remained absent in his family. Just give us the record of 19. Record number 19. Item number 19, sorry. Last occasion also, I think reminding.
Still 5-3. After that, no mention about the case.
It was simply a job.
Dates were given.
Only dates were given. These I have seen that no other order is there, only list accordingly list for hearing, that much only. So from here we cannot say whether he was absent or present. On 153 only one order was there, wherein he was present and requested for adjournment, I think. But the otherwise, your case is deferred only due to paucity of time or some
Yes, yes,
condition. That's why. So
And your lordship, may fixed on it on 9th lordship prior to.
no, that one I have fixed it 9th considering your situation. in
Yes,
fact.
lordship.
It will be immediately after vacation.
Lordship,
We cannot pass any, fix any date.
lordship, immediately after lordship, Bihu vacation date may kindly be fixed. Otherwise, it will not be listed.
Date, actually, we don't have
Lordship,
date, in fact.
Yes,
We
lordship,
don't
it is
have
a fact,
dates.
lordship, because
So we don't
earlier
have
also
dates.
lordship on several occasions, lordship, even
We'll see to it, we'll list it immediately after vacation. Then it may come after Bihu vacation also. Registry will do this one because we don't have any dates because already 20, 21st, 23rd, all are fixed, in fact. This
Yes,
is also hearing
but
matter.
more interesting, lordship, what happened, lordship, I make a mention for listing this matter, lordship, on lordship, before 2 weeks ago, lordship.
Okay.
But lordship, thereafter, the case file was not traced out in the registry, lordship. Thereafter, I make a prayer before the registry, lordship. Then now, lordship, this case is listed, lordship. So this is
I
happening
know, you are
without
facing,
fixing any
you are
date, lordship.
not only you, the other advocates also
Yes.
facing some problem.
So we
In
prefer
listing the matters
fixing
because of the overburden of the registry also.
Lordship,
Now
that's-
they had to deal,
we
if you
also.
go the outline benches, limited numbers of cases are there, so it is easy, but here Guwahati, you see, the position principles. Now, no one is, none appears on call for the petitioner side. Heard you, Mr.
NH Board.
NH Borbian, for the respondent side. Due to absence of the petitioner side, the matter could not be heard. List accordingly immediately after vacation. Raised is to fix the date immediately after vacation.
Immediately after winter vacation, we can.
Yes, winter. Oh, otherwise Bihu will
There
also come.
are another vacation also.
Bihu.
Yes, lordship, Bihu.
Oh, we'll see.
28.
Oh, like.
28 আছে নেকি our time? Oh, I thought 9 will have this. Supplementary.
Clear the lordship. Lordship, maybe matter with the kindly withdrawn, lordship.
You want to withdraw this one?
Yes, lordship. Matter, both are amicably settled, lordship. Both are.
Is already settled.
Divorce. Yes, lord.
Okay.
Order is passed. Lord.
You are for the petitioner?
Petitioner, lordship.
Your good
Mukesh
name?
Bora.
Huh?
And Borua on behalf of MD Choduri.
You are Mr. M.
And Borua.
N. Borua.
Oh, yes.
Heard Mr. N. Borua appearing on behalf of MS MD Chaudhary.
Yes.
MD Chaudhary. And it is submitted that the matter has already been amicably settled between the parties and hence the petitioner is not interested to proceed with the case further. Accordingly, please for withdrawal of the same. Prayer allowed, disposed of accordingly on withdrawal. Okay.